Yes.
May I make mention, my lord?
Hmm?
Item number 30 and 31.
30, 31. Hearing perhaps.
Yes, my lord. This matter was heard earlier,
Okay.
listed earlier many times, but it could not reach, my lord.
Huh.
In previous hearing, I have made prayer before your lordship. Your lordship advised me to make mention today. So
Okay.
this matter may be heard after motions item.
How long it will take? Criminal appeal.
Criminal, it will not
But
take.
whether you want to press for the IA today or
No.
the entire appeal?
No, main case.
Or main case?
Yes.
Criminal appeal will of course take around 1 hour or so.
Yes, it may take like that.
So otherwise it is there are.
But I will not take I will not take much time. I
Huh.
don't know whether PP will take time or not.
But let me go. I'll
But,
accommodate you.
It
somehow.
never is many times.
I'll sit till 4:30. So it will reach. But then there is one civil matter also.
My lord, it never reached.
Let me see after the admissions.
Yes, after admission of
After the admissions, okay.
Yes. Oblige, madam.
I'll give total word, but then we'll try it after the admissions.
Please call after admission. After admission.
There are bail hearings, right? After the bail hearings. In the second half, we will try, mister. In the second half. In the second half, we will try. Okay. F2, 230. Well, let's see. We will try. Then. Yes.
Lordship, in item number 25, order, Lordship.
25.
25, Lordship.
25.
Yes, Lordship. That I have filed IA with simple method, Lordship. That this is not listed, so this may be taken up.
IA you have filed.
Lordship.
That is not listed today.
Yes, yes.
So let it come up after 2 weeks or so.
Lordship, that it is just for vacation of the interim. That we are.
Of condonation of delay.
Yes.
There is a delay.
No, Lordship. Just interim was
Interim order
recall. Then for that purpose,
let it be listed along with this after 1 week.
Lordship,
After the vacation immediately.
no, Lordship, that this is for the arrest of this. This is for execution of this order. Then there some mention the prison imprison this arrest also. So on that case, that I am suffering, Your Honor.
So you want to do it today?
Your Honor, yes, Lordship. This is for IA for recall of this.
Otherwise, recall of any affidavit and all I know, but then IA has to be again listed.
Lordship, this is the reason I am mentioning, Lordship. This is I am mentioning IA.
So it has to be listed by the registry. Wait for 1 week. You're praying for execution of the some decision.
No, Lordship, this for continuation of this interim order, Lordship, only. This IA is for the continuation of the earlier interim order.
Interim order.
Yes, Lordship.
In the CRP.
Yes, Lordship. Sure.
Okay, let the matter be called. I'll see what I can do.
Oblige, Lordship.
May I please, my lord. My lord, I beg to mention item number 28.
28. Yes, that's.
My lord, I have taken the concern of Mr. O. Modi, my lord. I'm afraid he's out of station, so therefore, may I humbly pray, my lord, can the matter be fixed after 4 weeks, my lord?
On the prayer of Mr. Pada, you are Mr. Pada?
My lord.
Mr. O. Pada prays that the instant matter may be taken after 4 weeks on the ground that the counsel appearing for the respondent, Mr. O. Modi, is out of station. List the matter after 4 weeks.
Oblige.
May I, Your Lordship?
Yes.
Lordship, I beg to mention item number 27.
27.
Lordship, leading counsel J. Jongluju is out of station, so kindly matter may be adjourned. I have taken consent from the other parties.
Yes, on the prayer made by, your name is there.
T. Tojang.
T. Tojang.
T. Mosang. Sir.
T. Mosang, yes. On the prayer made by T. Mosang, the matter may be listed after?
After vacation, Lordship.
After the vacation. On the date to be fixed by the registry.
My lord, I beg to mention item number 6.
Item number 6.
The leading counsel for the petitioner is out of station.
Again, okay.
Kindly the matter may be fixed after vacation.
On the prayer made by, your name is there.
No.
You are appearing on behalf of?
Dikki Pangeng.
Dikki Pangeng, yes. On the prayer made by so and so. appearing on behalf of Mr. D.K. Pangi, list the matter after a vacation on a date to be fixed by the registrar. Yes.
Your Lordship, I'd like to mention item number 29. The councillor is from Guwahati, and because of some health issues, he is unable to appear today. So matter may be fixed on another date. And I have taken consent from other party also.
You are Mr.
G. Lombe, Your Honor.
Your name is not there.
No, Your Honor.
So and so appearing on behalf of,
Petitioner, Your Honor.
on behalf of Lokam Tadam.
Lokam Talo, Your Honor.
You don't have to write, but so and so appearing for the petitioner states that the conducting council is not present in the court today due to some personal difficulty. As such, he prays for a week's time.
Yes, Your Honor. It may be listed after vacation, Your Honor.
So he has prayed the matter to be listed after vacation.
29.
Fixed date may be given, my lord.
Oh, you are there?
Yes.
You are there for the respondent?
I am for respondent. Otherwise, this matter is
Ah.
2018
Mr.
matter.
You are Tarak, right?
Yes, G. Tarak.
Mr. G. Tarak appears for the respondent. List the matter on
22
22nd of July.
July, yes.
Okay, that is okay for you?
Yes.
22nd of July, 25.
All right.
Yes, Your Lordship, may I? Your Lordship, I beg to mention unlisted matter.
Today,
Yes, sir, for
what is the
today.
urgency?
Urgency is that, Your Honor, the trial court has directed the accused to make the it is actually a NI case, Your Honor. The trial case has directed to pay the twice amount of the check amount.
That is the law. You
Yes.
have, I mean, he is convicted. He is,
No, Your Honor, not convicted. Trial is still on the way.
Acha,
Yes, sir.
okay.
It is pending, and payment report has been fixed for in 2nd of July. So, Your Honor, matter may be taken up
and
today.
he is
sir.
directed to pay double the amount.
Double
of
the
each
amount. Yes, sir.
That should be actually after conviction.
Yes, Your Honor, actually,
But
that is
today,
there.
so many matters, it not be possible to take
Your Honor-
any unlisted matter today.
Your Honor, thereafter, if the case is not taken today by itself, then there is a vacation, court vacation, so urgency is there. Your Honor. Please, Your Honor.
Okay, right. Or there are many days left. Why today? Today is 30th.
Today is 30.
30th.
30.
Uh-huh.
Yes, sir.
So you have, your matter is on 2nd,
Second year.
if time permits, okay?
Okay. Obliged. Sir.
Yes,
Lordship, may I
revision.
please?
Yes. Against some judgment or what, or order?
Yes, my lord, here, assailing the rejection order of London District and Session Judge against the impugned judgment, that is conviction order against the NI Act.
Oh, so let the notice go today? Okay, she is there because the respondent has to appear. This is NI matter. She is only a performer respondent.
My lord, here, 138 section,
Huh.
here mandatory provision prohibit the sub-condition, sub-clause. That sub-clause B is not complied by the complainant.
Okay, today let the notice be issued to respond number 2. Your interim prayer will be considered upon appearing.
My lord, in the meantime, interim may be passed. Otherwise, they may file for execution. So, operation of the interim judgment.
Date, you can serve the notice. And then because interim order in their absence will not be proper, let them come. This is an NI matter.
In absence of, in the meantime, if the party go for execution, then it will ask for the petition.
It will not be so soon. Let it come up immediately after the vacation. On 21st of July. Nothing will be done. Let me Hear him also. Okay. Hear, heard Mr. Tartora.
Yes.
Here Tartora.
Yes.
Appearing for the petitioner. And Ms. Lakshmi Hage for the learned additional public prosecutor. The instant petition, the instant criminal revision petition is filed by the petitioner for instant petition is filed by the petitioner under section 442 and 438 of BNSS 2023 for setting aside of the impugned order dated 10/6/2025 passed in criminal appeal number 7 of 2025 by which the criminal appeal filed by the petitioner was dismissed. On what ground it was dismissed?
Ground of
Dismissed
petition is
is
without,
not required.
without perusing the
Ah,
record
okay.
available in the petition.
Issue notice to respondent number 2 by registered post with AD. Returnable in 3 weeks time, in 2 weeks. List the matter. Yes, list the matter after 3 weeks, after the vacation, immediately after on 21st of July. Okay.
May I please, Lordship? Lordship, this bail application is filed under
And
section.
in the earlier order, you write interim order to be considered on the next date. Yes.
Yes, Lordship, this bail application is filed under section 483 of BNS for granting the regular bail of alleged accused person Techimas.
What is the offense?
Lordship, he is arrested under section 64, 126, 127, and 115 sub clause 2 of BNS.
64 is what?
Rape, Lordship.
Rape.
Yes.
And 126?
126 is wrongful confinement, I think.
Oh, wrongful confinement. And 127?
No, Lordship, 126 is wrongful restraint and 127 is wrongful confinement. And 115 sub clause 2 is voluntary physical hurt. So,
Confinement. Let me see the FIR. This is a case for rape. Let me call the case diary.
yes, Lordship. So,
Only case diary.
yes, Lordship.
Heard Mr. Swenson. You are N. Rama,
N. Kuma.
N. Kuma.
Yes.
Mr. N. Kuma for the petitioner and
जी दादा
G. Tado, additional public prosecutor for the state of.
सीधी में भी कॉल करो
Yes. This is a bail application under section 483 of the BNSS for grant of regular bail to the petitioner in connection with Itanagar WPS case number 39 of 25, registered under section 64/126/127/115 subsection 2 of BNS 2023. Call for the case diary and list the matter. When can you bring it?
Lordship, matter will be fixed on this for Friday, Lordship.
Can they bring it so? What is this place? Papampare,
Yes, this is Itanagar only, Lordship.
Itanagar only.
Yes.
Can you bring it within 2 days?
with
Okay, then list the matter on what?
Yes, Lordship.
On 4th, I'll be leaving 3rd.
Yes, Lordship.
3rd, right?
yes
On 3rd of July, 2025.
Deeply authorized, Lordship.
482 petition, I mean,
Quashing petition.
uh,
My Lordship.
Uh.
Lordship, may I take Lordship to the page number?
committee FIR first.
Yes. FIR is page number 21.
21,
Type copy is it page number 22.
yes,
My Lordship.
yeah, read it.
It is to inform you that on 27/6/2020 at around 21 hours, one Sri Dinesh Gaur, son of Tufani Gaur, village Silapatar.
Dinesh Gar is the petitioner here.
Yes, Lordship, he's the victim. He's been made victim.
No, he's the victim.
Yes.
Bang Komi, okay.
Yes, Lordship.
One.
Here the informant is police officer, Lordship.
Oh,
My Lordship.
Dinesh Gar,
Yes. Dinesh Gaur, son of so and so, village Silapatar, Mazgaon, POPS, Silapatar, Assam, Dhemaji. The driver of truck bearing registration number AS so and so, Sri Natniel Mandal, son of Badia Mandal, village Silapatar, MS, POPS, Silapatar, district, Dhemaji, Assam. The driver of truck bearing number AR 015417887 and Sri Kendam Doke, son of so and so, village so and so, POPS Alo, district West Siang, driver of truck bearing registration,
three
yes,
handymen.
along with 3 handymen of the vehicle appeared at PS Tato and report that while coming back from Machuca after unloading the cement, 6 youths in a Maruti car 800 bearing registration number so and so between Rego village and 35 camp blocked the road by parking the car in the middle of the road. They snatched away the keys of the truck and checked the lockers of the truck in order to rob the money. When they didn't find money in the lockers of the truck, they searched body and pocket and forcefully took away rupees 950 from driver so and so and rupees 1030 from driver Dinesh Gaur. They also searched the body of other driver Sri Natnil Mandal but didn't find any cash. They also threatened us that why we are hiding money and lying them that we are not carrying any cash. They forcefully entered inside the truck and searched the vehicle thoroughly and for the cash and other items. In the meantime, one local person who has later identified it, so and so Tato town, who was on his way from Machuca to Tato, reached at spot and intervened. Seeing him, all the boys fled away from the spot. He also scolded the boy. Only because of his intervention, we could safely, since the place of occurrence falls under your jurisdiction, you are requested to take necessary. This is the FIR lodged. This is the FIR lodged by the one police officer. And Lordship, may I take Lordship to the page number 75?
Jebang Komi is there.
Yes.
He is not named.
Yes, none of the applicant is named. However, later the charge sheet was framed, a charge of framed against all the accused person, all the applicant here in Lordship.
In the charge sheet?
Yes, Lordship. Charge has been framed, Lordship.
During investigation, the names came.
Yes, names came, Lordship.
Okay.
May I take Lordship to the page number 75?
Paragraph, page?
Page number 75.
75.
Yes, Lordship.
There is any settlement?
Yes, this is the charge.
Achha. This is the charge.
Charge. Yes, Lordship. There were total 5 accused persons arrested, and however, the 2 accused persons, namely Sri Tabam Komi and Osu Lagasu.
This is charge framing. Where
Yes.
is the charge sheet?
Charge sheet, Lordship. Charge sheet as page number 52, Lordship.
Page number 18.
52, 52.
52. Yes.
My Lordship.
Don't have to read, I mean, the last operative, the relevant part.
Also relevant for this that
Or where is the name of the petitioner here?
second para, Lordship, initially.
Okay, okay. Jebang Komi.
Yes, Jebang Komi, Taki Heo,
Yeah.
Tabam Komi, Jebam Komi, Osu Lagasu, Vijay Dufing. Initially, there were 5 accused persons arrested, Lordship. And however, during the framing of charge, the two accused persons, namely Tabom Komi and Osu Lagasu, were declared juveniles, and they were discharged from the purview of the trial. And now the trial is conducted.
So
I-
charges are framed against three,
Yes, Lordship.
and you are one of them.
Yes, Lordship.
Charges are under 349, 1, 395, and 34.
341 wrongful restraint, Lordship, and 395 is a punishment for docketing, Lordship.
395 is
Punishment for docketing, Lordship.
dacoity.
Docketing.
341 is wrongful.
Wrongful
arrest.
restraint, Lordship. Now, Lordship, however, during the course of trial, all the prosecution witnesses, they were examined, and none of the prosecution witness has identified the accused person, Lordship.
How far the trial has reached?
Lordship.
What is the stage of the trial?
No, it is a stage of prosecution witnesses. Now, prosecution witness 11 has been summoned on this 3rd of this month, Lordship, next July, Lordship.
How many witnesses are there?
Lordship, there are 12 witnesses. And so far, 9 witnesses has been examined, and all of them, except the eye of the case, none of the witnesses has identified, and even none of the witnesses has corroborated the FIR with the allegation of the FIR, Lordship.
What about the injured? I mean, these eyewitnesses, these 3 truck drivers, they were
Yes.
examined.
Yes, Lordship, all were examined, Lordship. However, they did not mention anything about the alleged incident, and they did not identify the accused person.
No
Lordship.
TIP was held.
No TIP was conducted, Lordship.
Even in doc identification, they could not identify.
No, Lordship.
Show me their statement before
Yes,
the
Lordship.
trial court.
Yes, Lordship. In page number 77, Lordship. Type of fees at 79, Lordship. Not, my Lordship. Lordship, this is PW3.
This is yes, his name is Natlal
National
Mondal.
Mondal, Lordship.
He was one of the truck driver.
Yes, Lordship.
Now, let me
Lordship.
see the name.
Point number 4, Lordship. Type copy is at Lordship,
One
page
second,
number
one second.
79.
Let me match the name of the truck driver.
Yes, Lordship.
What? Tufani Gaur is Dinesh Gaur is one.
Yes.
Then no, Natyal Mondal.
Yes, Lordship.
Oh, acha, he's the one.
Yes, he's the one.
What did you say?
Lordship, page number 79 is a type copy, Lordship. Point number 4, Lordship.
Appearing in the court, I don't as defense witness.
Lordship, he is a prosecution witness, Lordship. Prosecution witness, PW3, Lordship.
But then he said I'm appearing as defense witness.
Yes, Lordship.
He
Maybe.
doesn't know the difference, I guess.
Yes, Lordship.
I don't recognize these 3 persons.
Yes, Lordship.
I don't recollect the date, month, year resulting in the present case. He is prosecution witness number what? 3.
3, Lordship.
I don't recollect resulting in down into my friend Vivek Mushahari was driving the car, driving the truck. What about other 2?
Other, Lordship, other witnesses, phase number 84, Lordship. PW4. He's an eyewitness. Said to be eyewitness. Yes, Lordship.
Nyape Rinia.
Yes, Lordship.
Nyape Rinia is not named in the FIR. I mean, as
No, Lordship, he has been named as eyewitness by the IO of the
he
case,
is
Lordship.
driver.
No, he's not a driver.
We found 2 groups comprising, one group was stopping the cars and the boys from another group was trying to check inside the cabin. I mean, he is the person who came because he is the person who I think had come to the place of occurrence and seeing them, they fled.
Yes,
Right.
IO, Lordship, IO has made 3 persons as eyewitness, Lordship.
Local
Now, one
person.
of them is Sinya Perinya, Lordship.
And what else? What about the other two truck drivers?
Other 2 truck drivers, Lordship, phase number 86, Lordship.
Acha. Kenzom Doke.
Yes, Lordship.
Okay. He's otherwise Kendam Doke. Here it's written Kenzom Doke.
Yes, Lordship.
Witness declared hostile.
Yes, Lordship, but in cross-examination, he has stated that I have not stated before the police that some person have taken away rupees so-and-so from me and only returned rupees so-and-so.
And
Nor I have stated before the police they had body search, Lordship.
what about other one?
Lordship, page number 87, Lordship.
His name is what?
Dinesh Gaur, Lordship.
Page number?
87. Lordship.
It was COVID period. I along with so and so for coming back. They just stopped. Now it's about documents. While in the meantime, some people came in the voice federal. So no recognition, nothing.
Yes, Lordship. Even the IO did not conduct a TIF, and even mandate of section 41B was not fulfilled.
What do you say, Mr. Louis?
Yes.
See, the case is very, one had turned hostile,
Yes.
one had not recognized, and the other did not even say anything.
Allegation is, Lord, the offense is serious, but the hostile.
Now, he's saying the stage of the witness, the stage of the trial is that few witnesses are yet to be examined, right?
Yes.
The police.
Yes,
police
only-
did not
only-
examine.
Only police were examined, but initial IO has to be examined now. They have been called on this.
It's not examined.
IO has examined, Lordship, but there were 2 IO initially.
Okay. So, see, they have not, what about 161 statement? Have you annexed?
Yes, Lordship, 161 statement I have annexed, but all the 161 statement has been.
No, 161 statement, have you annexed?
Yes, Lordship.
Just show the driver statement.
Page 64, Lordship.
Of course, one has turned hostile. 64.
Yes, Lordship.
This is
Nintila
Natia Monda.
Nintila Monda.
along with so and so. We were train trucks, the way 5 persons in Maruti blocked the road. Smashed a case. They told him. So they said those 5 persons from the Maruti car blocked the road by parking. They snatched away the keys, checked the lockers. They took 60 and a beer packet from among them. One person was showing me identity card. You are inside jail since?
No, Lordship, I am not in jail now. Lordship, trial is underway, Lordship.
Oh, this is for quashing.
Yes.
I thought it's a bail application.
So, Lordship,
Now that only because there is a decision of the Supreme Court, quashing should not be entertained at the last stage of the.
Lordship, however, there is.
That the genie placed that judgment. That quashing should not be entertained when the state. Or it was.
No,
bail.
Lordship, there is a judgment.
bail.
Also, there is also a judgment that is saying that the quashing can be done at
bail.
this stage of the trial, Lordship.
It was bail. That was bail at
Yes.
the last stage of the trial.
Yes. Here, Lordship, it is not bail, it is quashing of the criminal process also.
Now, since what I'm
No,
thinking is.
Lordship,
what
X
I'm-
versus register was for by bail, Lordship. Pursued not in the not into Lordship. Entertain the bail, Lordship.
That is bail matter, Lordship. Bail, Lordship.
Bail matter.
Oh, that was a bail matter, yeah,
X
now I
versus
remember.
register was for.
That will have an impact on the trial and all, it is said.
Yes.
So what I'll do is,
CD may be called, or TRC may be called for Lordship. Okay.
no, you have already annexed the FIR, those things. What about respondents? The informant is a police officer for which he can appear. And why have you added so many persons as respondents?
Lordship, there has been made this respondent as a
Dinesh
victim.
Gaurav, even the accused person.
Yes.
Yeah.
Oh, no, the
He's a victim,
the
Lordship.
victim.
The police has made them as a victim, Lordship. So,
Okay, what I'll do is I'll stay
Yes.
the proceeding and I'll issue notice to the victims.
Lordship.
Let them come and reply, and otherwise you seem to have a good strong case, but then since the main witnesses have not stated anything against you. Okay,
Lordship.
heard Mr. It's okay with you? Let him come. and then- Heard Mr. Your Ingo,
R.A. Lordship.
R. Ingo for the petitioner, as well as D. Loi, the public prosecutor for the state of Arunachal Pradesh. This is a petition. You can set. This is a petition filed under
528
huh,
BNSS, Lordship.
528 of BNSS 2023 for quashing of the criminal proceeding arising out of sessions case number
04.
4 of 2021 pending before District and Sessions Court Alo, West Siang District Alo. Full stop. The case, the prosecution case, as is revealed from the FIR, dated 28/6/2020, is that. And the prosecution case, as is revealed from the FIR dated so and so, lodged by the police officer of Tato Police Station,
Yes, Lordship.
wherein it was stated that on 27/6/2020 at around 21 hours, at about 9 p.m. It will be 9 p.m., right?
Yes, 9.
At about, not very night also, at about 9 p.m., three trucks driven by respondent number 32, who are Apu Bora and Raja Bosumotari. They are also victim.
They-
How come they are
No,
victim?
they are not a victim. They were a handyman, Lordship.
They are handy.
Just assisting the truck.
Driven by respondent number 325. You change it at around so and so 9 p.m. Respondent number 326, who were the truck drivers, were coming from Majuka and on their way between Rago village and camp. Okay. Were coming from Machuca and while they were on their way, 6 youths in Maruti car blocked the road by parking their car in the middle of the road. And that they stopped the trucks, snatched the keys from the truck drivers, and checked the lockers of the truck. And when they did not find any money there, they searched the body of the truck drivers and forcefully took away whatever cash they could get from them. It was also alleged that they threatened the drivers as well as went inside the truck and searched the vehicle thoroughly. But however, in the meantime, one local person arrived and the accused persons fled from the scene, SCENE. On receipt of the FIR, the police registered the case under section 341/395 slash is what?
506, Lord Sir.
506.
Initially, case was raised.
506. 34 was not there.
Yes, initially 34 was not there, but during
It
the
was in the charge frame.
yes, framing of charge.
Okay, not required. 506 of the IPC. Thereafter, charge sheet was submitted. Thereafter, on completion of the investigation, the police submitted charge sheet. White charge sheet number 7 of 20, dated 4/10/2020. And submitted the same before the court below. Thereafter, the Learned Court of District and Session Judge, Alo Sessions Division, Alo, West Siang District, after hearing the accused persons as well as the public prosecutor on point of charges, framed charge against the petitioners. There's only one petition here.
Yeah.
Against the petitioner and two others, right? And two others under section 341, 395 and 34 of the IPC. You write 395, read with section 34 of the IPC. Achha, before that, just write somewhere. Before, on completion of investigation, you write. During investigation, the police identified the, on what basis they identified? Something written in the charge sheet?
Lord Sir, they have arrested.
Achha.
Like his-
The police, during investigation, the police found out the accused persons. And the petitioner was one amongst them. And then you come last. The Learned Court during the said charge framing had acquitted two of the accused persons for lack of prima facie case against him.
Lord Sir, they were declared juveniles.
Oh, they were declared juveniles.
Yes.
Where is that?
Page number 75.
Where is the declaration of you have carefully?
Lord Sir, page number 75, para 4, para. Sir, third.
The Learned Court declared two of the accused persons named by the police as juveniles, and the case was referred to the board.
Lord Sir, it is not reflected in the.
Have declared two of them as juveniles. Full stop. Thereafter, the trial was thereafter the trial proceeded against the three accused persons, amongst whom the petitioner was one. Altogether, 13 witnesses, 12 witnesses, right?
Yes, correct.
Altogether, 12 witnesses were 12 persons were arraigned as witnesses in the instant case, and out of them, 9 witnesses were already examined during the trial. Para. Mr. R. Ingo submits before this court that the petitioner was not named in the FIR and in the charge sheet, no materials were placed. Right, na? Right. There was no materials
No.
against him, only that they were recognized and they were identified and all, right?
Yes. They were not-
In the charge sheet, the police did not place any materials to show the complicity of the petitioner in the present incident. He had placed the statements of the truck drivers adduced before the learned trial court during the trial. And stated that none of them had named or had identified the petitioner to have committed the offense. Where is the first track? Page 77, right?
Yes. Page number 6.
PW3. Acha, no, not required. Full story. He further states that since there are no materials against the petitioner being collected so far, he prays that the instant proceeding may be quashed for the ends of justice. Mr. D. Louis, the learned public prosecutor, has, however, submitted that the records may be called for and the victims may be heard. Full stop. He further stated that since the offense in question is serious and grave, no quashing should be allowed. No quashing of the proceeding may be allowed in the instant case. You should actually amend the prayer because you have to ask quashing qua your petitioner.
Lordship.
That you have not made.
Lordship, I have.
Achha, just show me. You have simply written quashing of the everything,
Yes.
but qua the petitioner, because there are other petitioners, there are other accused person.
Yes, Lordship. There are 3 accused persons and they have filed separate application before this honorable court, Lordship.
And this is only one.
Yes, this is the first application.
Item number
Item number
5 is.
So they are also listed.
Yes, Lordship. Yes.
Then what did I say? Oh, he said all this. Okay. I have heard the counsels and have gone through the records. It is noticed It is noticed that since it is a case where 6 unidentified youths is alleged to have committed dacoity, not committed dacoity, 6 is alleged to have stopped the vehicle and forcefully snatched the cash amount from the drivers of the said vehicle. And they are not identified and they are not known persons to the victims. The prosecution should have conducted the test identification period in order to identify the accused persons involved in the offense. It is noticed that the same has not been done till date. Same has not been done, not till date. It is also noticed that the truck drivers have not identified the accused persons. The petitioner has not identified the petitioner before the learned trial court during their deposition in connection with the trial. One of them, where is that trial statement?
Page number 86.
One of them, 86, right? One of them was declared hostile. The other, another one, Nipirinia, right?
Yeah,
84 also a truck driver?
No, he's
He is the independent eyewitness, Lordship.
Okay. Well,
truck driver is 86 Lordship. Second
no,
truck.
there was one more.
Yes,
Dinesh Gaur.
Guinness Record 87 Lordship.
The other one, said that some boys had stopped the vehicle but did not identify the accused person in the dock. And what about the other one?
86 Lordship.
86 I've seen.
Yes, 86.
87, right?
Yes, 86, 87 and 77.
And the other truck driver stated before court that he does not recognize the accused persons. In view of the same, this court, in the interim, suspense, oblique stays the further criminal proceedings in connection with the sessions case number 4 of 2021, pending before the District and Sessions Court Alo, West Siang District Alo, against the petitioner till the next returnable date. Issue notice. Mr. Loy appears for respondent number 1 and 2. As such, no formal notice will be required to be given. Additional copies may be served upon him during the course of the day. Issue notice to respondent number 3 to 7 by registered post with AD or with usual process. List the matter. after 3 weeks. Okay, you take steps. The petitioner to take steps for service of notice upon respondent number so and so to so and so within a period of 3 days from today.
Lordship, at least 5 days.
Your holidays will come 3 days.
Then 7 days, Lordship.
Huh?
Then 7 days, Lordship.
No, holidays. We have to take steps within 3 days
Lordship.
from today.
Lordship, item number 3, yes, 4 and 5 is same, Lordship. Yes, there.
So same order,
Same
we
order.
just change the name
Name.
of the parties.
Yes.
4 and 5 are also those
Yes, Lordship.
other 3.
The other 2 accused among 3, Lordship. Earlier.
Seven is Jeannie, your matter, where you said that,
No, Your Lordship, this is a civil revision, Your Lordship.
no, this matter I think came up on an earlier occasion. Yes. It came up, my last order raised it.
Yes, Your Lord.
Yes.
Your Lordship, the issue here is very, of a very simple nature. If I may take Your Lordship to page number 18, Your Lordship.
This has been admitted, right?
Yes, Your Lordship.
Okay.
The only issue here is that there was a Kaba, Your Lordship. So Kaba had passed an order in favor of
The respondent is served. He is
yes,
appearing.
yes, he has filed an affidavit to Your Lordship.
Pleadings are complete.
Completed.
It can be taken up for disposal.
Yes, Your Lordship.
You are ready, mister? You are ready?
Yes.
Then it can be taken up for disposal. I'm disposing.
Yes. If I may take Your Lordship to page number 18, Your Lordship.
18, yes.
The petitioner and the
Respondent
respondent.
Bango level.
Yes.
Just tell me one thing. Bango level is the original, the first.
It's an appellant.
This is appellate.
Actually, appellant have an appellant jurisdiction, Your Lordship.
The first decision will be by Kebang.
Kaba, village Kaba, yes.
And this
Bango itself means that it's a culmination of all the village, head of all the villages, Your Lordship.
Kebang is one village.
One village where the jurisdiction lies. Your Lordship.
This is not the original decision.
This is an original decision, Your Lordship. There were Kabas between the party, both the respondent and the petitioner are husband and wife, Your Lordship. There was an issue of divorce, Your Lordship. So it was taken to the Bango level Kaba, Your Lordship.
Or it was not taken to the first.
There were Kabas held between the family on many occasions, Your Lordship.
Okay.
Finally, the Bango level Kaba has passed an order in favor of both the parties, dividing as to what the liabilities of the parties are. If I may take Your Lordship to page number 18, the fourth paragraph, Your Lordship.
Yes.
Lordship, after hearing the complainant and the respondent and also the witnesses, the GB appointed by the DC Pasar has passed the following. That majority of the Kaba member had passed in favor of for divorce, and majority of the Kaba had also directed that none of the parties shall disturb each other henceforth. That she so and so shall identify the beaded necklace, Your Lordship, ornaments. The bead.
He
He was one of the member of the Kaba, Your Lordship.
He's not related to the parties.
Not parties. Shall identify the beaded necklaces ornament, the beaded lisum ornament, and the beaded necklace ornament of Gaikirodi shall be given to Bagra. That allotment of the land was gifted by Sri Minjom Bagra, who is the petitioner, Your Lordship, to Srimati Mahba Pasar Bagra.
She is the wife.
She is the wife. Shall be returned back to Bagra, and henceforth Srimati so-and-so shall be known as Miss so-and-so. And a land measuring about 824 square meter, and so-and-so may collect all belongings from the house of Bagra. More particularly.
And that the land measures about so-and-so.
Yes, Your Lordship.
Which she has to give it back
Back
to
to him, Your Lordship. So this land was gifted to the wife by the husband, Your Lordship. However, after divorce, there was a direction that you return the land which was gifted to you as a wife to the husband, Your Lordship. And the Sridhan of the wife, that was to be identified by one Gekirori and should be handed over to the wife, Your Lordship.
These ornaments.
Yes.
Okay.
Thereafter, if I may take your lordship to
They have put their signatures.
put their signatures, your lordship.
This is, I think, translated. Where is the original?
Original is your lordship. Your lordship will see a page number
Yes.
13, your lordship.
13.
Both 1 and 2, complainant and respondent, your lordship. Complainant is the wife and the respondent is.
But
the
where are the signature? Wife has not put the signature.
It's there, your lordship will see after Miss Meba Basar, H. Bagra is written, your lordship.
Acha, acha, acha. That
And
is the signature.
Signature, yes. Thereafter, your lordship, if your lordship will see, this order was passed in the year 2019 when the civil call did not come into existence, your lordship. Subsequently, we had at page number 20 and 21 is a type copy, your lordship. The Kaba had informed the same to the petition, the DC concerned that this is what the order was passed by the Kaba.
Why DOC? This is Deputy Commissioner what?
Yes, your lordship.
Or
Basar, your lordship.
but the abbreviation is DOC?
It might have been wrongly written, your lordship.
No, in the original also it is DOC.
Yes, your lordship. It's a ADC which has been wrongly typed as DOC, your lordship.
Okay.
Now, subsequently, your lordship,
This one what? The information was given.
yes, your lordship. Now, at page number 22, your lordship will see that a petition was filed by the respondent, your lordship. If I may just read the cause title, your lordship. A petition against irrational prayer of so-and-so, dated so-and-so for dismissal, where she had sought for direction from this office to order land management branch of Basar not to take up any kind of application filed on behalf of Sri Minjom Bagra, herein after referred to as applicant in connection with allotted land until settlement of alleged missing brass so-and-so. So there was an application made by the petitioner herein for change of the allotment, the name in the allotment of this particular land, which was decided by the Kaba. So there was an objection made by the wife, your lordship, that no such change of name in the land allotment certificate has to be done until unless those ornaments and those stridans are not returned to the wife, your lordship. Now, subsequently, if your lordship, I may take your lordship to page number 27, your lordship. 28 is a typed copy, your lordship.
Okay. So her articles was not given back.
Yes, as per her allegations, your
Her
lordship.
allegations,
Yes, your lordship.
What is this 28?
28 is an order passed by the Deputy Commissioner, your lordship. Now, your lordship will see that it was passed on 9th June 2021, which is when the Civil Cat Act came into existence. If I may just read the second last paragraph, your lordship. Considering the claim and counterclaim of both parties, this court fitted deemed to endorse the case for settlement in arbitration as per the provision under section 38 of AFR 1995, your lordship, 1945. Thereafter, again on.
But AFR is gone.
Yes. Again on 6th of September, which your lordship will find at page number 30, your lordship. There was a reminder, your lordship, by the Deputy Commissioner that both, if I may read the last line, your lordship. Therefore, both the parties are directed to submit the list of their arbitrators, which will be 7 in numbers each. The list of arbitrators shall be submitted to this office on or before 30 September 2021. Now, these two orders were challenged before this honorable court, wide WPC 23 of 2022, your lordship will find it page number 31, your lordship. Yes. Now, they have not contested this writ petition even after service of notice, your lordship.
The wife, no.
The wife, your lordship. Now, if I may take to the relevant paragraph, which is at page number 33, your lordship. If I may read paragraph 5 and 9, your lordship. Yes. If I may read paragraph 5, your lordship. To the above contention made by the petitioner, the state respondent through the affidavit filed by the respondent number 2 in paragraph 14 thereof has stated that when the impugn order dated 9/6/2021 and 6/9/2021 were passed, the respondent number 2 and 3, which is the state, were unaware about the deletion of section 38 of Assam Frontier Administration of Justice Regulation Act 1945.
This is too much to say that you should know at least.
Yes.
This repealing of the
yes,
they were not aware.
Thereafter, Your Lordship, in paragraph 9, Your Lordship, while disposing our application, writ petition, Your Lordship, the petitioner in the respondent number 4 shall however be at liberty to approach the appropriate forum for resolution of the dispute if so advised, Your Lordship. After this, Your Lordship will see neither the Kaba was, any appeal was filed before the concerned court, Your Lordship, by the wife, Your Lordship.
The concerned appellate court will be D6 court.
If it was in 2019, Your Lordship, or 2020, Your Lordship, it would have been before the Deputy Commissioner, Your Lordship. After 2021, Your Lordship, it's either the Bango, the higher authority in the village level, Your Lordship, or the judicial courts, Your Lordship. Now, they have not applied for appeal, Your Lordship. Neither they have filed any application challenging any of these orders, Your Lordship. Subsequently, we had intimated
Any limitation provided for appeal?
30 days in terms before the Bango level Kaba, Your Lordship. Otherwise, a regular of 90 days before the judicial court, Your Lordship. Thereafter, Your Lordship, we have forwarded at page number 35, Your Lordship will see, we have forwarded the order of the pass in the WPC, Your Lordship, and prayed the Deputy Commissioner for execution of the order, Your Lordship. Since the DC subsequently in the civil court has given the executing power, Your Lordship, they have not executed the order till date, Your Lordship.
Yes.
If I may take, Your Lordship, because all of them are applications, Your Lordship, at page number 48, if I may take, Your Lordship, to the last application that we have given, Your Lordship.
Page number?
48.
Yes.
Your Lordship. This is an application filed by the petitioner, Your Lordship, before the Deputy Commissioner on 11th November 2024, Your Lordship.
Disposal of representations.
Yes. Order dated so and so. If I may take, Your Lordship, to 49, page number 49, Your Lordship. Pursuant to the order of the Honorable High Court, I had appeared before your office on several occasions. However, there was no response on your behalf. I was also informed by reliable sources that Miss So-and-so was in process of disposing the land after the order of the Kaba, as well as of the High Court to the MLA contender Srimati So-and-so of Leparada. On having come to know about the same, I had immediately visited your office along with my advocate and intimated about the same. A hearing was also conducted and assurance was given verbally that notice of execution shall be given to previous owner Miss So-and-so. However, no notice were issued. Subsequently, I approached your office on countless occasions. However, interestingly, I have not been given any update on my case, and in fact, I have been told that the file has been misplaced, and I was also asked to come on another date. To my surprise, on approaching your office on given date still today, the file has not been found, Your Lordship. Now, if I may take, Your Lordship, to the affidavit filed by the government, Your Lordship.
Who has to execute this Kebang's decision?
The Deputy Commissioner.
Is it provided?
Yes,
somewhere?
yes. If I'll just place the there was an amendment of 2023, Your Lordship, in the in the Arunachal Pradesh Civil Court Act, Your Lordship. If I may take, Your Lordship, to section 4, Your Lordship.
Section 4. Okay.
Amendment of clause 11 and 14 of subsection 1 of section 27. In section 27 of the Principal Act, in subsection 1, clause 9 shall be read as under. For subsection 2 of section 45 of the Assam Frontier Administration of Justice Regulation 1945, the following shall be substituted. Execution and enforcement of the order or decree passed by the village authority. If the person against whom a decree or order has been passed by the village authority fails to comply or pay or comply with such order or decree within a period of 30 days, the party in whose favor such decree or order has been passed may apply to the concerned Deputy Commissioner or Assistant Commissioner as the case may be for execution or enforcement of the decree or order of the village authority. The concerned Deputy Commissioner or the Assistant Commissioner as the case may be on receipt of such application may call for records of the order or decree of the village authority and execute or enforce the same by following the principle laid down in the Code of Civil Procedure.
In spirit.
Yes. Now, since the Deputy Commissioner, we had approached the Deputy Commissioner on the many occasions, Your Lordship. Now, if I may, if Your Lordship take up the affidavit filed by the government, Your Lordship.
Only 2 paragraphs.
Your Lordship, I'll just take, Your Lordship, to paragraph.
Dusty.
government's
Respondent number one.
respondent number one, Your Lordship.
Huh.
Your Lordship, if I may take Your Lordship to paragraph 10, 12 and 14, Your Lordship. If I may read paragraph 10, Your Lordship.
10, wait, one second. Yes, 10.
10. That with regard to the statement made in paragraph 8 of the civil revision petition, the answering respondent denies the same and begs to state that your humble respondent number one has made his endeavor to dispose of the instant matter, but unfortunately failed to do the same. However, after receiving the application dated 15/4/21 from the present petitioner, your respondent number one has admitted the same and fixed the dates for hearing, and matter is still pending before the respondent number one. At paragraph 12, Your Lordship, that with regard to the statement made in paragraph 10 of the civil revision petition, the answering respondent denies and same and begs to state that your humble respondent number one has not refused to perform his obligation, rather made his endeavor to dispose of the instant matter despite of his other time-bound administrative and development workload. And as such, the reason, facts and circumstances stated herein above, the instant matter is pending. Now, if I may take Your Lordship to paragraph 14, Your Lordship. That with regard to the statements made in paragraph 12 of the civil revision, the answering respondent denies and begs to state that since from the beginning, respondent number one made his endeavor to dispose the instant matter despite of his other time-bound administrative and development work. However, on 17/5/2023, respondent number one has passed an order in connection with execution of the instant case, and on 12/6/2023, an application has been received by respondent number two with an allegation of non-compliance of KABA decision dated 2019 by the petitioner, along with a counterclaim against the execution petition of the petitioner. Thereafter, respondent unable to take the matter due to busy in other administrative work and simultaneously parliamentary and state assembly election 2024, and as such the matter is still pending. Now, Your Lordship will see the deputy commissioner has admitted to the fact that the matter for execution is pending only because of he being overloaded with administrative work, Your Lordship. He is not able to take up the matter. Now, since
there is a complaint by the
this is a yes counterclaim by the wife. Now, our only prayer is, Your Lordship, these whatsoever steps taken by the deputy commissioner has never been informed to us. Neither a copy of the counterclaim was also given to us, and therefore we had approached this court because our last application is dated 11th of November 2024. Even on that day, they had only intimated us that the file is lost. Only through this affidavit, we had come to know that in the year 2023, they had filed a counterclaim to Your Lordship. Now, our only prayer before this honorable court is that since the execution petition is pending, admitted by the deputy commissioner, even only for the execution of this KABA decision, Your Lordship, if there is any counterclaim by the petitioner and by the petitioner as well as by the respondent, they can claim it before the executing court, Your Lordship. Our only prayer is that since the execution as admitted by the petitioner is pending before the deputy commissioner, to take up this matter, because the order of KABA was passed in the year 2019, Your Lordship. Even by this honorable court in 2021 by WPC, the matter has been disposed of with regard to the orders of the deputy commissioner. Even till date, after a lapse of 5 years, the execution, as simple as it is, Your Lordship, has not been executed. Our only prayer before this court is for an early disposal of my execution petition, Your Lordship.
And what about the land? Land is still
no, we have filed an application for the land transfer of the land name in the land certificate, Your Lordship. That itself is a part of the execution, Your Lordship.
And she has agreed.
Yes, she had agreed. Their only concern is that their Sridan as a whole has not been given to her, Your Lordship. That will be done by the executing court. If any counterclaim is made, that certain claims, because there is no specification in the KABA order that these ornaments of this number, brass plates of this number, or any clothes of this number are to be given to the petitioner, to the wife, Your Lordship. The execution court can deal with that if she is claiming for certain numbers of Sridan, if it's there before the husband or not, can be seen only when the execution and when the execution is being executed, Your Lordship.
So that executing court can again go into?
Yes, Your Lordship, because Your Lordship will see that the KABA order at page number 18 deals with only two parts, Your Lordship. One is that one person was appointed to identify at page number 18, Your Lordship.
Yes.
One person was appointed to identify the beaded necklace.
Okay. Geki Rodi.
Yes, the beaded Lizum is also a beaded necklace, Your Lordship, and a beaded necklace, and there is nothing as such to brass plates or anything, only the ornaments, Your Lordship. This person shall identify it, and so even during the execution, only this land and the ornaments parts are to be executed, Your Lordship. That has to be seen by the executing court.
So nothing on the, what you said, that brass.
Brass plates. There is nothing with regard to brass plates. Even
What
in
is the complaint of 16(9) by the lady, by the girl? Has she mentioned in her affidavit?
no, Your Lordship.
That what the complaint was dated what? I forgot. It's in the DC's order.
No, Your Lordship. Only in the Kaba order, Your Lordship. Kaba order, only in the first paragraph, there is a allegation of mental harassment and physical assault.
No, those are, I mean, the complaint that she has made before the DC.
Yes,
That
Your
her things are not back.
Yes.
Where is that complaint?
It's not available, Your Lordship. Neither they have annexed it.
Have you annexed that?
There is an order by the Deputy Commissioner.
Okay, then if it is not there, I'll come back to your letter finish.
Yes.
So our only prayer to this date is that since we have approached this court, that the executing court is not doing their duty for execution of my Kaba order, which is of 2019 order, Your Lordship. Now, admittedly, since from their affidavit, it's clear that the executing petition is pending and they are in terms of executing the same, Your Lordship. However,
No, execution will be only in terms of the ornaments and the land.
and the land, nothing more than
Nothing
that.
more.
Yes,
Her complaining about some other articles will not affect this.
absolutely, Your Lordship.
For that, she had to file something. She has
Neither-
other remedies.
Absolutely. Neither appeal was filed to challenge this Kaba order, Your Lordship. Subsequently, she had not participated in before this honorable court in the writ petition, Your Lordship, and the order was passed ex parte. However, taking into consideration that this was an issue between husband and wife, this honorable court, in a very lenient manner, has even granted a liberty to both the parties to approach the concerned authority for appropriate actions, Your Lordship.
That is in the writ petition order. In the
Yes, Your Lordship.
Right, yes.
That was only we have approached the court for the execution of the order, Your Lordship. Even that writ petition's order was also never challenged, Your Lordship. Till date, there is no challenge of any of the orders, Your Lordship.
She didn't even appear, no?
Yes, Your Lordship. Only our prayer
Whether
is
the
that.
notice was served upon her.
Yes, Your Lordship. After receiving the notice, none of them appeared. She did not even appoint a counsel, Your Lordship. That was also reflected in the order of the writ petition, Your Lordship.
So your case is only for execution of that Kebang decision.
Yes, Your Lordship.
Okay. So anything more?
Yes, Your Lordship. Only if a time period, because the petitioner here is a very old man, Your Lordship. Yes, Your Lordship. Since we have been waiting for execution of this particular
I
court,
thought he is a young boy. I mean,
no, Your Lordship.
Acha.
The
And why
petitioner,
was land not given back to him?
the only contention before
Is that because the
he did not return the brass plates
Brass.
and other ornaments, Your Lordship. The
But
only
that cannot be a ground for her not to return.
absolutely, they could have challenged any of before any of the appropriate forum, Your Lordship. That has not been done. Even before the executing court, if they place their grievance, that could have been decided. The executing court would have taken action of if whatever she is claiming is part of the Kaba order or not, Your Lordship. Even that was not done, and therefore pendency of this has not on. I'm already 67 years of age, Your Lordship, and unfortunately, with regard to this land, Your Lordship, as I have already given in my representation dated 2024, Your Lordship, that this land was in the verge of getting disposed even after the orders of both the Kaba and the High Court. It was
That
in the
I've
verge.
seen that she wants
Yes.
to sell it to someone.
Yes, Your Lordship. Even work had started and we have stopped it, and we have also made a complaint before the Deputy Commissioner. However, even after that, no execution was done, Your Lordship. That is my only prayer, Your Lordship, that it may be disposed of, directing the Deputy Commissioner to execute the Kaba order, Your Lordship.
As per this amendment, right?
Yes, yes.
Yes. Who is appearing for the deputy commissioner? You are then government advocate. Your you have written in the affidavit, I've seen that you have made endeavors, but then
Yes.
it was not done because of the reasons of other duties.
Yes.
As well as she has filed some complaint.
Yeah. And we have in the meantime filed,
Hmm.
issued one order also, Your Lordship, may kindly see page 65, Your Lordship, of my affidavit.
65.
Yes, Your Lord.
Yes. That is the order.
Yes.
Hmm.
The petitioner has filed, for.
This was given to both the parties.
Both the parties, Your Lordship.
Just read it out. Where is three?
Whereas
So-and-so?
Sri Minjam Bagra submitted an application on 16 May 2023 along with relevant documents requesting for early disposal of his application for transfer of the ownership of the land at Dori Complex Basar measuring 824 square meter from Srimati Basar to the applicant Sri Minjam Bagra in terms of the decision of the Kaba dated 16/9/2019, and whereas as per record, the matter was already viewed by competent court and order passed. And whereas he has also submitted separate application on 16/5/2023 requesting for invoking of power under section 145 CRPC against the land dispute between him and Srimati Niba Basar, who reportedly unauthorizedly seeks to sell land to Srimati Nyati Singh. Therefore, both the parties are hereby directed to maintain status quo till clarity is ascertained on ownership of that land in the said case. Further, both the parties are also directed that no illegal construction, sale, or any activities to be undertaken till matter is resolved, Your Lordship. After this status quo order was passed, Your Lordship, we have received the representation by the private respondent, Your Lordship, for non-compliance of Kaba decision, Your Lordship.
Page 66.
Yes, Your Lordship, page 66, Your Lordship.
This is by the petitioner.
By the respondent, Your Lordship.
Oh, this is what I wanted to see. I
Yes.
think. This is what?
Since petitioner has not complied with the point number 2 of the Kaba decision, Your Lordship,
But it's nothing, it's not written in the KEBA that this has to be followed after that. This. The terms have
but
to
she
be
has to
followed.
be returned, her ornament has to be returned back. That has not been done, Your Lordship.
Ornaments means three of the ornaments which has been mentioned in the KEBA.
All her belongings, Your Lordship.
But that's not written, na? See the KEBA decision, three, some necklace or something. Shall identify beaded necklace, ornament, the beaded lisum, and the beaded necklace. And shall give it to Bagra. Nothing beyond that. It's not talking of the entire street and or whatever.
But I think those things also, Your Lordship, in her representation, if you see, Your Lordship, nothing has been received by her.
But then as far as the KEBA decision, this is only these three. And the land.
Yes.
And she did not challenge. She had participated here. Yes, after hearing complainant and he responded. She has participated, she has signed. Acha, says, show me that complaint. What did she write?
66, Your Lordship.
With regard to the object, I am most certain the KEBA decision was passed.
Testimonial dispute case between myself and Sri Minjam Bagra before the village authority of Basar Bango. As per the Kaba decision, the village authorities decided that I should return back the government's allotted land between 8 and 4 kilometers gifted to me by Sri Minjam Bagra. The divorce between myself and Sri Minjam Bagra was decided and accepted. The Kaba also decided that Sri Minjam Bagra should return back all the local ornaments.
No, that is incorrect. All the local ornaments, no, these are only three. Street hunt to be given by my relatives during my existence.
As five and all.
This is actually not in total consonance with the KEBA decision.
But till date, the local ornaments are not returned to, those three ornaments, maybe they have not returned back to Basar. As per report of the Deputy Commissioner Lafarada, dated 19 September 2019, some village authorities of West Siang District and Lafarada District were appointed by the district administration to monitor the handing and checking of local ornaments from residents of Sri Minjam Bagra. The OCPS ALO was also personally directed to monitor the process of collection of personal belongings of me and to ensure peace and order during collection.
However, during arrival at Bagra House at Alu, it was found that all the belongings of Lee were missing. The family of Sri Minjong Bagra was creating disturbances and causing nuisance, and the local ornaments was not returned, Your Lordship. And the list of ornaments she has annexed, Your Lordship. The next page, Your Lordship. Madam, the government allotted land measuring 824 square meter is in my name. I'm paying the land revenue to the government regularly. It is true that the said land was acquired by me and Sri Minjong Bangra some years ago during our matrimonial ties were in existence, but it is purely a government land and the village authority do not have any jurisdiction to decide in matters concerning government-related land. Moreover, being a wife, even if divorced, I did not get any alimony or maintenance with regards to share household from him. I have been exploited morally, physically, and financially by him. He even did not return the local ornaments and brass plates returned in compliance with the decision of the Kaba. Matter was brought before the notice of the district administration. Sri Nyaya Vibhag, GB, Ravi and Sri Jonkar Basajiri Nigam are the village authority from Basar who were sent to Alu for collection of my Sridhan and are the witnesses who will testify whether my properties are given back to me or not. My counterclaim, Madam, I claim all my Sridhan to be returned back to me as I may be compensated rupees 30 lakhs only if my Sridhan cannot be returned. Therefore, it is my humble request to consider my application and direct Mr. Minjong Bagra to return back all the documents to me. This is
This is not, and where is that 19 September 29, where village authorities were supposed to accompany and take while she takes her local ornaments? Is it there on record?
64.
No, it's not there.
Hmm? 19 September.
19 September, page 64, Your Lordship. 64 is the type code.
Acha,
This is the order.
okay. This is what she is referring to, right?
Yes, yes.
In pursuance to the order.
That's why the village council under Quashing regulation 1945. The matter of divorce case Minjong Bagra versus Niva Basar following order are passed. The divorce case has been settled at Basar on 15 and 16 September 2019, wherein separation by divorce has been amicably accepted by both the parties. The personal belonging of Srimati Niva Basar, which is kept at the residence of Sri Minjong Bagra at Alu, shall be collected by her in presence of the following GBs. There are 4 GBs. The OCPS Alu shall personally monitor the entire process of collection of personal belonging of Srimati Niva Basar and to ensure that peace and order is well maintained during such collection. The both parties will implement to OCPS Alu. One day
It has gone much ahead of the Keba resolution, right? From these 3 ornaments, it went to the entire belongings. It went too far. Okay, then. As far as this execution of the Keba decision, there is no impediment, nothing. And if she wants some other articles, she has her own remedies. She can file any application like it is filed for taking back the Sridhan.
Absolutely, Your Lordship. Even Your Lordship will see, even for the maintenance that she's claiming for the house and the 30 lakhs,
Alimony maintenance.
that can be done before the appropriate call under the appropriate provisions, Your Lordship. However, execution court, as since the Deputy Commissioner is here, Your Lordship, executing court has to only not go beyond whatever order is being passed, Your Lordship. Even in the order of 19 September 20, when certain people were appointed, Your Lordship will see there is never a list of cases, only a personal belonging. What a personal belonging would include. It does not include Sridhan. There is nothing as written to as Sridhan, Your Lordship. If that is to be claimed, Your Lordship, appropriate forum may be approached.
Okay, what is? Yes.
Madam,
What's
it? My sister has actually wrong in the petition of the Kaba decision.
What,
Actually.
sister? What did you say?
Actually, Your Lordship, this has been drafted in Galo. Galo, since my sister is also Galo, I am also Galo. It has written that the beaded necklace of Sri Gatur Ori has to be identified by him and which has been kept in as mortgage shall be returned back to Gatur Ori. This is a separate thing. which has been passed in the Kaba proceeding.
Hmm.
And kindly peruse at the last line of the Kaba, which is translated version,
Wait,
page number 86 of my counter affidavit.
86.
Yes, it is also annexed by my sister also.
Hmm. Yes. The same one.
Yes, sir. It is written in Galo version as Ok Miba Basarga Alo Bagra Nam Yara.
Wait.
I'm reading at page number 83. It is written in Galo version.
Oh, acha. 83.
Yes.
Oh, read the translated part. I don't
Yes.
know that language.
It is written as
Ah.
and Miba Bazar may collect all her belongings from house of Bagra at Alo.
Where it is not written.
Kindly please, number 86. 86 of my.
Oh, and the lane Miss Man Miba Basar.
Yes.
Miba Basar is the you.
Yes.
Miba Basar may collect all her belongings from the house. Acha, that this sentence I have missed.
Yes, sir.
And Miba Basar may collect all her belongings from house of Bagra at Alur.
Yes, and the things my sister is repairing is the local necklace, which is of one series, Gurkhur Ori, which has been kept in mortgage.
Which one?
The fourth that starts with that Gakur Ori.
That Gurkhur Ori shall identify the beaded necklace.
Gekir Ori.
Yes.
Shall identify, yes. Then?
It is wrongly interpreted actually. In Galo, it is written as Ok Gurkhur Ori Tadokam identifier. That means Gurkhur Ori has to identify the necklace. Ok Tadok Bondok Ana means this necklace has been kept in a mortgage.
Also, translated is not problem.
Yeah,
Not proper.
there is a problem in the translated version. That's why there is a difficulty. Actually, Your Honor, honestly, I'm submitting since Kaba was passed, and there was a Kaba condition that I have to return back the land which has been gifted by my husband, ex-husband, in my paper in the year 2010. And since then, I'm paying the land revenue. And that land has been acquired during our matrimonial relationship. The Kaba authority has actually passed this order illegally, but I have not challenged the same. So this is not
You have not challenged it.
yes, no challenge. But as per the Kaba decision,
Because you are
The-
satisfied.
Kaba decision, what the Kaba has decided that I have to return back the land to Minjam Bagra. And the Minjam Bagra had to allow me to collect all my belongings. Thereafter, what happened? You will see kindly peruse page number 89. Just have seen you.
Yes.
I have lodged a complaint before the Deputy Commissioner. This is no.
Application of 24th September. That we have seen, I think.
Yes, this was challenged. This was challenged by the writ petitioner.
This order is challenged.
Yes, this was
Where?
challenged and the same was passed.
Before the honorable.
Oh yes, to appoint arbitrator. Yes.
Yes. Because I have not
It is
participated,
gone.
but it was not participated by me and it was passed in my absence.
But then petitioner is saying the notice is served.
But as per my instruction,
Which one? Writ petition.
notice was served as per the record itself, but as per my instruction, she has no idea about
I'll
it.
just take your lordship to page number 32, your lordship. Such
Yes,
kind of allegation.
I admit that notice was served.
But then
Yes.
you did not participate.
Yes. And it cannot be challenged because the order was itself is illegal. They cannot be. Prior to that, your lordship kindly,
Now, what objection do you have in execution?
my objection is that since my ornaments, the precious ornaments, were not given back to me by the petitioner, therefore there is a difficulty. If I may be allowed to get back all my precious ornaments, then it can be executed.
This is actually not the prayer. I mean, you can ask the executing authority.
Yes, that's
But
why.
as far as execution of this,
Yes, my submission would be recorded that since the Kaba terms and condition was not complied by the petitioner, and same has been brought before the concerned authority by the respondent. And if execution has to be done, then in compliance of strict in compliance of the Kaba proceeding, Kaba decision.
But you have not filed anything.
Your Honor, I'm admitting if he will me to get back my belonging, then it can be executed. And this has been passed by the Kaba authority itself. Kaba has directed that I may be allowed to get back all my belongings. But when I went to collect my belonging, I was restricted by the petitioner and his family members. Therefore, I lodged a complaint before the Deputy Commissioner.
And what did Deputy Commissioner say? That because of that, he could not execute.
Because of his workload in the administrative.
And her complaint, he could not.
After the Kaba decision,
For violation of the Keba decision,
yes,
in case we think that he has also violated, he did not let her take the articles.
Yes.
Your Honor.
yes.
Then you have a remedy. You have to go, instead of making a complaint to the DC, you can knock the
Since
doors
the
of the
Deputy
court.
Commissioner itself is the executing authority now.
You could have again given a complaint to the Kebang.
Kaba, absolutely.
Kebang.
Because those people who were appointed, Your Lordship, were they given any list of the, because it's just say personal belongings. Were they were submitted with any list of her belongings that was to be taken from the house of the husband, Your Lordship? All those things
You
are
could have filed a complaint for the Kebang again.
Well, it's finally page number 88 of my petition opposition. Pursuant to Kaba decision, the members were appointed.
Members were appointed. They went with you.
Yes,
But then they say, you are saying that they did not allow.
yes,
Few things are missing.
yes.
Those things are there.
And thereafter, I'll file application before the Deputy Commissioner that I have not been allowed to get back my belonging. It is in page number 89. And based on my application, the arbitrator was appointed and same was telling before this.
But then again, that is also gone. Because 38 no longer subsists.
Your Honor,
So your only remedy is that you should have gone to Kebang again. Instead of,
Kaba has
Complaint.
already passed the decision.
that is, okay, after that there are violations, you can again go. Can't you go?
Since she has filed for the execution, I'm also ready to execute if the strict compliance of the Kaba decision would be done. If my personal belongings,
This will be never ending. You will again say that no, things are not given, missing, I will not hand over the land. So this will continue.
we kindly appreciate the fact that the land which has been acquired by me and petitioner during our marital relationship, and same has been gifted by me, and which has been now in my name.
That has
since
certain finality.
since-
You have to give him back.
Since 2010, I'm paying land revenue
Doesn't
for the
it?
sale.
But then it is decided that attained finality, you have not filed an appeal. So, ma'am, land has to go back to him.
Yes, I will give him back the land if he allow me to collect my belongings.
This
But
dispute
it was-
cannot be settled by the High Court.
It's a
Let-
saying that I'll make a contempt against the order of the court until unless the court does not give me a favorable order. That's
He is also praying before this another court to execute for the execution of the Kaba proceeding. I'm also ready, but strict terms and conditions of the Kaba. Kaba has decided that the land shall be given back to him, and I may be allowed to get back my belonging from the house of the petitioner. It was the decision of the Kaba.
Now see, the deputy
Without
commissioner-
complying the Kaba proceeding, how can only I would be
only I and
compelled
you,
to
doing only I and you will not suffice because the Keba decision is that she should get back the articles. You have, yes, she should get back the articles and he will get back the land.
yes, that is there.
So
If I'm a-
execution proceeding could not be done by the DC because he was busy in some other work.
During
He
the
has also not said that because of the complaint I am not executing.
absolutely.
He had simply mentioned that
That
there is a complaint.
complaint.
See the disease
Counter
order.
complaint.
Where is the disease order?
Lordship,
Oh, in his affidavit.
in his affidavit at para 14, Your Lordship,
page 89,
10, 12 and 14.
Page?
14, Your Lordship. Page number 60 of the affidavit.
Yes, 60. Yes, he said, see, I had passed an order in connection with the execution of the instant case and on 12/6 an application was received with an allegation of non-compliance of the KEBA decision by the petitioner along with a counterclaim against the execution proceeding. Thereafter, respondent unable to take up matter due to busy work. The only reason is that he is busy with other administrative work. This cannot be a reason also that he is not executing. No, he had simply said there is a complaint. He did not say because of that I am postponing or whatever. So what requires to be done in prima facie view is that they should execute the KEBA order. And whatever allegations you have other remedies. Either stated before the executing
Yes,
authority.
yes, Your Honor. That's why I'm submitting, Your Honor. If direction is being given to the execution authority, so it should be like strictly in terms and condition of the KEBA decision.
That's what is required. It
Yes,
has to be. Right.
yes.
But the KEBA decision is not very, they have not given any details as to how the belongings will come. Of course, DC has appointed that committee who will go and collect the, assist the lady to collect the belongings.
Yes, Your Honor. Because in the KEBA decision itself, it was decided that I may be allowed to get back my belongings from the house of the petitioner. It was the decision of the KEBA.
So what is the reply? What do you say?
Your Lordship, I'll just clarify because there might be an impression upon this court, as has been put that page number 86 of the KEBA decision that they have annexed and page number 18 of my KEBA decision that I have annexed in my petitions are a ditto, Your Lordship.
And
So-
what is the wrong in translation?
There is nothing wrong. That's what I was comparing, Your Lordship. Even I had stated in the last line, Your Lordship, this is a ditto of
Your translation is also in our
Same.
translation is same. Then you are saying that it is not translated properly. Where is the mistake?
Okay, it is my mistake that I have not translated in my own version, Your Honor.
no, both the
I have
translated
just
copies are
annexed
same.
the documents which she has annexed.
Why will you do that? You have annexed this. You should have translated it yourself.
Your Honor,
Anyway, what is the mistake?
the expert can be called if this is in dispute here.
Hmm?
For the Galo translation. If it is in dispute, Your Honor, I'm disputing this translation version, Your Honor.
So he is disputing the translation. It's his duty to come with a proper translated copy because such kind of allegations are an impression put upon the court that the counsels are misleading, Your Lordship.
Then let the registry look into the matter and get a proper translation.
Yes, Your Honor, that can be done.
Your Lordship, I'll just. My only prayer is that, Your Lordship, the is submitted by him.
Because I
See,
don't know anything.
so I'm Galo, but honestly submitting before this, Honor, because I'm not expert in Galo.
So, Your
I know Galo, but I'm not an expert in Galo. But since this.
You
order
don't have to be an
comes-
expert in Galo.
I-
I can translate Assamese language
Yes.
into English.
No, Your Honor,
I'm not an
no,
expert
this
in
is-
English.
This is order passed by the KEBA authority. They have different language of their
No,
Galo person.
I'll just come to that, Your Lordship. Since I'm an expert in Galo, Your Lordship, I'll just come to the point where he's making an allegation, Your Lordship. If Your Lordship can come to page number 81, Your Lordship.
Yes.
If I may read the last two line 81, Your Lordship.
Oh.
This is the original copy, Your Lordship. There are Galo fellow advocates standing here, Your Lordship. If I am wrong in any manner, that will maybe corrected, Your Lordship. Last two lines states, Okka Muba Basarga Alo Bagranam Aga Yera Laru Laregu.
Akka Yeram.
Akka Yeram Laregu. Meaning thereby Okka thereafter Miba Basar shall take her belongings from Alo Bagra house. This is what is written in my translated copy, Your Lordship, which has
What he's disputing is the first line. The Gekir only shall identify.
Identify the
That
backline.
you see this, he is disputing this.
if I may read, Your Lordship. Gekir ori tadok kam identify re okka tadok bandok anam sigum Sri Gakar Origa Tadokam Bagra Jido Kuba pass 2. Meaning thereby that is Gakar Ori shall identify the ornaments, your lordship, and Gakar Ori's ornament is to be given to the Bagra, your lordship.
So same. What is the wrong in it? What is the mistake or in it?
And
No.
He
only
will identify the necklace.
Yes.
And there-
That is kept in mortgage. Bondok means
Oh, that mortgage part is not there. Is it there in the original? I mean the
Bondok Anam.
means that has been kept in somewhere in mortgage.
letter.
Amen.
Bondok is independent as soon as it is mortgage, but I don't think so. It will be in Garo. See,
That's why, Your Honor, there is need of
is it
proper.
is it given
translated-
in
But then
mortgage?
it's clearly written even in the translated copy, your lordship. The Gokar Ori shall identify the beaded necklace, the beaded lisum so and so, and beaded necklace of Gekir Ori shall be given to Bagra. Of
No, he's
Gekir
saying-
Ori.
Now he is saying that it was given in mortgage or what?
Yes, somewhere. Bondok Anam means it has been kept in mortgage somewhere here.
So even if admitting that it was kept in a mortgage, these ornaments are to be given to Gokar Ori. Your lordship.
But then the translation, according to you, is also wrong.
Yes, your lordship. Or with regard to, because it does not reflect that it was kept in mortgage, only that Bondok part, your lordship. But then only with regard to these two parties, your lordship. One is the land and other is the last line of the Kaba decision with regard to her belongings from the house of Bagra at Alo. If that is to be taken, your lordship, if Gekir Ori's ornaments were kept as a mortgage
What is the prayer in the petition?
for early disposal of the execution
Dispose
petition.
of the execution proceedings. So you are not contesting if I direct that this deputy commissioner as empowered under this one should dispose of the should execute the Kebang decision as early as possible?
Yes,
In
yes.
terms of the Kebang, sorry.
Yes, yes.
Yes,
In terms of the Kavadi.
yes. Even our
It's
prayer
strictly in Kavadi.
Because in that situation, what will happen, the ground that he has taken, that he has not been able to do because of Ali, other duties, that he will have to let go, and then he'll have to decide on this.
Yes.
Okay?
That-
This
that
is
in
the
the-
only, this
Yes,
is,
yes.
Our prayer
Very
is
simple.
simple as it is that it has to be expeditious. If there is a counter complaint, be it taken by the executing magistrate, your lordship. Any issues?
Acha, right. This, heard Miss Jeannie and Mr.
I vomit.
Your name is there?
Yes, Your Honor. It's there.
G Talo? No, no.
No, I vomit.
Hmm.
Idag vomit.
But so Jeannie for and so and so. This is an application under Article 227 of the Constitution of India. Read this section 151 of the CPC. By which the petitioner has prayed for issuance of a direction to respondent number 1. That is the learned Deputy Commissioner, Basar, Leprada District, Arunachal Pradesh, to dispose of the execution proceeding in connection with pending in connection with Keba order dated 16/9/2019. Full stop. The facts of the instant case is that on 16/9/2019, on a complaint filed by respondent number 2 before the Deputy Commissioner Basar, You don't write on a complaint. A complaint is filed before the DC Basar against the petitioner for marital, mental harassment and physical assault committed by the petitioner, alleged to have committed by the petitioner. In pursuant to the complaint, the DC Basar, you can sit, Jenny, and just, in pursuant to the complaint, the DC Basar appointed, what is head Gaubura, right?
Yes, Your
C, what is C, what does C stands for?
Sure.
Chief head Gaubura or what?
It ought to have been just head Gambura, I'm not sure. Just circle head Gambura.
Appointed the head Gaubura as the chairman of the committee and directed him to conduct a Bango level to decide the said case. Full stop. After hearing both the parties as well as the witnesses, the chairman decided in terms of the decision of the majority of the KEBA member that the both parties should get divorced and that none will disturb each other henceforth. None will disturb each other since then. It was also decided that Gekir Ori shall identify the beaded necklace and the beaded lisum and the said necklace shall be given back to the petitioner. Oh, she was given back to respond number 3. 2. It was also decided that a plot of land measuring 824 square meter, which was given by the petitioner to respondent number 2 during the marriage, should be returned back to the petitioner. Furthermore, it was decided that that respondent number 2 may collect her belongings from the house of the petitioner. This KEBA decision was accepted by both the parties and both of them had put their signatures on the same. Thereafter, on 23rd of September 2019, the KEBA chairman, Basar Bango level, intimated the said decision to the Deputy Commissioner Basar, Leprada district. Thereafter, what happened? Thereafter, this one, no? This committee to collect her articles.
Yes, Your Lordship.
Where is that?
That is on 19th of September. Your Lordship will find it.
Page number-
19th of September.
Yes, page number 88 in my affidavit in opposition. Page number 88.
Oh, before, I mean, then what you do is the one that I have dictated about 23rd September, you take it later, and before that you write. Thereafter, on 19th of September 2019, the Deputy Commissioner constituted a committee comprising of the head Gaon Bura as well as Gaon Bura of 4 number of villages to accompany petitioner number 2,
Corner number 2.
respondent number 2 in collection of her personal belongings from the residence of the petitioner. Full stop. The Deputy Commissioner also directed the OC, the officer in charge of the police station, to monitor the entire process of collection of the said personal belongings. And also to ensure, and also to name, by ensuring peace and order during the said collection. Thereafter, you write that on 23rd September and so and so.
May I please, Your Lordship?
Hmm.
Very good. Hereafter, an application was filed on 24 September 2019 by the respondent number 2.
When? Which one?
It will find it page number 89, 9 June 2021.
Page number?
89.
89.
It is written as page number 89. Page number. Where is an application dated 24 September 2000?
That I have seen. That too will come later.
Oh.
Because this was in June 21. Then what did I say? On 23rd September, he communicated, the DC communicated, the Keba chairman. This district, by stating inter alia that as per the Keba decision, the petitioner and respondent number 2 had divorced each other, and that it was decided further that respondent number 2 would return the land measuring 824 square meters to the petitioner as a return gift to the petitioner. Where is that letter or whatever complaint by the by respondent number 2? Before this application, we have annexed as an 4.
Your Lordship will find it page number 22 of my petition, Your Lordship.
No, 22 is C. This is a petition against the irrational prayer of Misa Basar, filed on 14 September.
Yes.
Where is this 14 September? You have not annexed, I guess.
Yes.
Huh? Again, you have to go back. Huh? I'll arrange it before you type it out. On 14 September, the respondent number 2 had made a complaint before the Deputy Commissioner seeking for a direction that the Deputy Commissioner should not take up any application filed on behalf of the petitioner for transfer of the land until her articles were not given back. And in pursuance to the same, the petitioner also made an application before the Deputy Commissioner that the complaint of respondent number 2 is irrational and baseless, and that the Deputy Commissioner may proceed with the transfer of the land to the petitioner. Thereafter, the petitioner made a number of representations to the Deputy Commissioner for execution of the KEBA decision dated 16/9/2019. Since the said KEBA decision has not been executed till date, the petitioner has filed this petition for early execution, not early, for execution of the said KEBA decision. Ms. Jenny, appearing for the petitioner, submitted before this court that the KEBA decision dated 16/9/2019 was after hearing both the parties and also the witnesses present therein, and it was wherein it was decided that ornaments, wherein it was decided that both the parties would get divorced, and that the ornaments of respondent number 2 were to be given back to her, and that the land which was gifted by the petitioner to respondent number 2 had to be was to be returned to the petitioner. She submitted that against this KEBA decision, no appeal or no application whatsoever no appeal was preferred. No, not application, Choro. No appeal was preferred before the appellate authority, and that the order and that the decision of the KEBA, Bango level KEBA, had attained finality. She has also submitted that a number of times the representations were made to the Deputy Commissioner by the petitioner for execution of the KEBA decision, but nothing has been done so far. She further stated that the Deputy Commissioner, by order dated, where the arbitration was ordered, where is that order, Jimmy?
Arbitration, at page number 28, Your Lordship.
The Deputy Commissioner, by order dated 9th June 2021,
And the subsequent order is at page number 30, Your Lordship.
9 June 2021, had ordered that since there were claims and counterclaims from both the parties, the matter was directed to be referred for arbitration as per provision as per provision under section 38 of AFR 1945. In the said order, the learned Deputy Commissioner had also stipulated that there are complaints from respondent number 2 that some of her personal properties, such as local ornaments and brass plates, was found missing from the residence of the petitioner, and as such, she could not collect it. Therefore, the Deputy Commissioner, not therefore, is corrected. The Deputy Commissioner, by the said order, directed the parties to submit list of arbitrators for settlement of the dispute. Again, on 6th of September 2021, the learned Deputy Commissioner ordered, by way of a reminder to both the parties, to submit the list of arbitrators, since it was not listed by them. However, the petitioner challenged both the orders by filing a writ petition, being WPC 23 of 2022, before the Honorable Guwahati High Court, on the ground that Section 38 of Assam Frontier AFR 1945 was deleted by deleted by virtue of coming into force of the Arunachal Pradesh Civil Court Act 2021. Full stop. The Honorable High Court by order dated 19/9/2022 dismissed or quashed both the order dated 9/6/21 and 6/9/21, and had ordered that the parties may approach appropriate forum for resolution of the dispute. The said order of the Honorable High Court was forwarded to the Deputy Commissioner by the petitioner by letter dated. What is the date here? 29/1 or what?
29/1/2022, Your Lordship.
No, it cannot be. The order is 19/9. Order is 19/9 and he's making application 29/1.
Ah,
Oh, no, the
wrong.
order is 28/1. No.
No, Your Lordship, this application has been,
Oh, it is stay order. Perhaps
This-
after the stay order.
yes, this is the stay order. The subsequent application, Your Lordship will find that, page number 47, Your Lordship.
Yes. What the has been communicated? Not forwarded, don't write forwarded. Yes, forwarded by letter dated 13/10/2023.
22, Your Lordship.
24.
22, Your Lordship.
22. 13/10/2022. Thereafter, the petitioners, she further submits that thereafter, the petitioners have further made representations to the learned Deputy Commissioner, but the same was not acted upon by the said authority. On the other hand, this is all by you, Ginny?
Yes,
Miss-
yes, yes, Lordship.
On the other hand, the government advocate appearing for respondent number 1 by placing reliance upon the affidavit filed on 10/4/2025 stated that the Deputy Commissioner had made all the endeavors to execute the Kebang decision. However, the same could not be done in view of many reasons, such as due to outbreak of the pandemic of COVID-19, the petitioners could not appear before him. As well as also due to the reason that although he tried his best, but due to other time-bound administrative and developmental workload, he could not complete the process as per the Kebang decision. She submitted that on 17/5/2023, the learned Deputy Commissioner passed an order in connection with the instant case. And that he had also received an application from respondent number 2 alleging non-compliance of Kebang decision by the petitioner. And for settling the claims and the counterclaims, he had ordered for an arbitration between the parties. But then he was not aware that the enabling provision for arbitration was done away with by the Arunachal Pradesh Civil Court Act 2021. She as such submitted that much efforts were made by the learned Deputy Commissioner, but the same could not be put into action for reasons for valid reasons. Mr. So-and-so, appearing for respondent number 2, submits submits before this court that the terms of the settlement arrived in the Kebang decision was not followed by the petitioner concerned. He stated that it was directed in the Kebang decision that respondent number 2 would collect all her belongings from the house of the petitioner. But when she went along with the committee members formed by the Deputy Commissioner, she found that most of her ornaments were missing, and she was confronted with of resistance by the families of the petitioner during the time during the collection. He therefore stated that respondent number 2 had as such lodged a complaint before the Deputy Commissioner on
24/9/2019.
Where is that?
It will be reflected from the page number 89.
Page?
89.
No.
It is within it, where is application dated 24.
But if you showed that 24 orders, application also.
It is not there in the record. But as per this order, it can be seen that application was filed on 24th September 2019.
No, 12 June letter is there. 12 June is there. 12 June 23.
Before that, page number 89. It is order passed by the Deputy Commissioner on 9 June 2021. And
that is for settlement. It's okay. This is 24th September. He placed that what he said? What is it? On 24th of September 2019, stating inter alia that her, where is his application? That her local ornaments as well as brass items were not given to her as per the direction of the Kebang decision, and as such, she prayed that that the land in question, no, as such, what did I say? I mean, and that therefore the learned deputy commissioner should not take up the application of the petitioner praying for handing over the land to him. He had also placed an application made by respondent number 2 on 12th of June 23, wherein she stated that the petitioner had not complied with the KEBA decision and she had also prayed therein that she did not get any alimony or maintenance till date. He also stated that the land in question was gifted to her by the petitioner during the subsistence of the marriage and that she has been paying land revenue since the date of the gifting, showing the ownership of the land upon her. And since part of the KEBA decision was not followed by the petitioner, he is also not, or she is also not entitled to follow the rest. I've heard the counsels appearing for both the parties and have gone through the records. Even in this book, as it is noticed that the petitioner has prayed for the execution of the KEBA decision dated 16/9/2019. Which clearly shows the actions to be undertaken by both the parties. In the said decision, the specific exercise to be undertaken was that 2 numbers of ornaments, that is lisum, beaded lisum, and a beaded necklace were to be given back to respondent number 2. The land which was gifted by respondent number 2 to the petitioner, gifted by petitioner to respondent number 2 was to be returned to the petitioner. Land measuring 824 square meter. Further, that respondent number 2 will be known as Miba Basar Full stop. And lastly, that respondent number 2 would collect her belongings from the house of the petitioner. In the said Keba decision, what are the belongings that needs to be collected from the house of the petitioner was not mentioned. The said Keba decision was accepted by both the parties. The petitioner, the respondent number 2 had never filed any appeal challenging the same before any higher authority. In pursuance to the said Kebang decision, the Deputy Commissioner had constituted a committee consisting of 4 head Gaumburas and Gaumburas to assist respondent number 2 to collect her belongings from the house of the petitioner. And there is nothing on record to show, I'm right now, and there is nothing on record to show that the committee had ever complained to the learned Deputy Commissioner that the collection was not done peacefully, or that few collections could not be made at all. There is no complaint from the committee members.
No, but there is.
You have said,
In our
but no
affidavit-
complaint from them.
In our affidavit, we have stated in paragraph 9, Your Lordship.
Acha. Show me.
Last line, Your Lordship. However, page 58. Paragraph 9, page 58.
Hmm.
However,
To submit a
However-
report.
however, starting however.
Ah.
However, the
Submitting-
state board member submitted the report, and after perusal of the same, it was revealed that the petitioner has misled the respondent number 1 through his application dated 18/10/2019 regarding the compliance of point number B of Kaba decision, which was actually not complied with. After the case was once again kept in abeyance till the application dated 15/4/2021 was filed by the petitioner.
Wait. Who is the petitioner and all? The said
Sir.
board submitted their report, and after
Yes.
perusal of the same, it was revealed that petitioner means boy.
Yes,
Petitioner.
yes. The
That
petitioner.
petitioner has misled respondent number 1, DC,
Yes,
through his application dated 18/10 regarding compliance point number B. Compliance point number B is Harry.
collection of ornaments, Your Lordship.
Collection of ornaments.
Yes,
Of Keba decision, which was actually not complied with.
yes.
So these 2 necklaces were not collected.
Yes, as per the report, it was not collected.
Your Lordship, such kind of, neither they have filed any annexure to substantiate their stand. However, my 18 October, the application that they are referring to is at page number 22, Your Lordship.
No, report is not annexed, but it's a pleaded case, and
Yes.
it's a note.
Yes.
Which page?
22 is the application that they are referring to, Your Lordship.
This I've seen, yes.
After this, there is nothing to substantiate that I had misled, Your Lordship. There is no annexure, even they have not annexed, Your Lordship. Even otherwise, I'll just take Your Lordship to page number 21, Your Lordship. Twenty-one is after Kaba was on 16/9. This is a compliance order by the head Gambura, if I may read, Your Lordship. With due respect, Kaba chairman, like to inform you that as per Bango level Kaba decision, Sri Minjom Bagra and Srimati so-and-so divorce each other. According to Kaba decision, Srimati agreed to return a plot of land as a return gift to Sri so-and-so. So Kaba chairman like to request you to kindly separate so-and-so. This was
This was before she complained.
this
No.
this was
After she-
after this Kaba was passed. Your Lordship. This was since this Deputy Commissioner has given to the Kaba, Your Lordship, this was an information by the chairman of the head Gambura reporting the same to the Deputy Commissioner.
It's okay, that I have mentioned. That.
Yes.
Okay, what did I say? This has to be again reformed. You just changed that, there's nothing on record. What did I say? There's nothing on record to show that the has ever complained that collection of, you write collection of her local ornaments, collection of her local ornaments and brass articles. However, in the affidavit in opposition of respondent number 1, it was stated that the board members had submitted one report and that the report reveals that the petitioner a report revealed that point B of the Keba decision was not complied with. That is, handing over the 2 numbers of necklaces to respondent number 2. Thereafter, respondent number 2 by lodging a complaint on 24th, right? On 24th or what? On 24th September 2019, before the learned Deputy Commissioner, had stated that that some of her personal properties, such as precious local ornaments and brass plates, were found missing from the house of the petitioner. Wherein she also prayed that the land allotment matter may not be taken up till her properties are handed over. It is noticed that the learned Deputy Commissioner had given much efforts to execute the Kebang decision, but however, due to his other pre-allotted time-bound works and due to the complaint lodged by respondent number 2, the said execution proceeding could not be finalized due to the said unavoidable reasons. Para. By virtue of amendment to section 27 of the Assam Arunachal Pradesh Civil Courts Act 2021 by virtue of amendment, White APCC Amendment Act 2022 to Section 27 of APPP Act 2021 subsection 2 of Section 45 of the AFR 1945 was substituted by the following clauses. I have given X to X, just quote it. It is seen from the above provision that if the appellate authority, if the executing authority, that if the person against whom the decree has been passed by the village authority fail to comply within a period of 30 days, the party in whose favor the decree was passed may apply to the Deputy Commissioner for execution of the same. And that the Deputy Commissioner or the Assistant Commissioner, as the case may be, may execute and enforce the same by following the principles of the CPC 1980-1998 in spirit. It is therefore mandated by law that the Deputy Commissioner is duty bound to execute the decision of the village authority, that is the Kebang decision, execute the Kebang decision. The Kebang decision is only for handing over the ornaments by petitioner to respondent number 2 and her belongings, ornaments and her belongings, which is not specified in the decision to respondent number 2, and the land measuring 824 square meter gifted by petitioner to respondent number 2 to be given back to the petitioner. As the belongings mentioned in the Keba decision is not specified, the same may not be stressed by taking it, by interpreting it by virtue of the list given in the complaint letter dated 12th of June 2023 by the respondent number 2. However, the other two conditions, other two requirements has to be strictly executed in view of the decision. It is also stated, it is also provided in the amendment. No, it is also provided in section 45 of the AFR Act. AFR 1945, that the decree has to be complied, the decree has to be executed within a period of 30 days. And it is noticed that many years have elapsed by since the date of the Kebang decision. As such, it is directed that the learned Deputy Commissioner may execute the Kebang decision as early as possible. Strictly in terms with the decision dated 16/9/2019. And the rest some here and there I'll make, but then strictly. And then you see, it is written belongings, but it cannot be stretched for so far to the articles as she has mentioned there. If we take the decision in its true purport, so these condition has to be fulfilled, and rest they will decide. And little I'll add that they will, the executing court will further decide
Yes, yes,
in the interest of justice.
yes.
The further it is directed that the executing court may take into account while executing the Kebang decision the requirements in the interest of justice. Further, it is directed that the parties aggrieved by any inaction or action of each other may resort to the available remedies given under the law. They can resort, you can make any application. For street run, you can make application. But as far as Kebang decision, let it be executed. If the land is sold to someone else and all, and she is bent upon not to give the land, she said, I'm paying land revenue and all, but that will not matter. There is a decision for you to give over.
I mean, there is no direction for this street and maintenance every morning.
That you did not challenge. Or that
Yes.
part I will write.
Yes,
She
sir.
did not challenge.
Yes, sir. It has to be executed strictly in terms of the capacity.
Okay, I've written that. Let the decision take an action.
Yes.
Okay.
Yes.
There's some here and there. I'll make something.
Yes.
Okay. Deeply. Come. Oh. Okay. Rest at 2.
Lordship, item number 22, it's in order, the service is awaited. So,
You want to go?
yes, Lordship, because service is awaited for respondent number 2. So,
22.
yes, and interim is there, and TCR may also call, trial court recall.
You wait for some time or you allot some junior. When I take up, because I'll take up his criminal appeal after the orders.
Okay.
Okay. I'll finish it first after
Okay,
the
I will
orders
wait.
I'll take up. You can go somewhere and come back after an hour or so.
Okay.
And Miss T. Ginny, what happened in that matter, I have made some some additions.
Yes, sir.
You can tell the other advocate also, where I have said that one, after signing petition, cannot say that if the other party do not consider or do not comply with his part, I will also not comply.
Yes.
That cannot be a ground.
Yes.
That I have added.
I'll just inform the other side.
If there is any violation,
Yes.
you have other remedies.
Yes, yes, yes.
That you inform him.
Deeply.
Okay.
May I please, Your Lordship? Lordship, this is for quashing on merits.
But Landed Council has not filed their affidavit in opposition.
Affidavit lordship not required.
It's a criminal appeal, not, but
Yes.
this time he took some time.
On previous occasion also, I denied to file a reply letter.
Is it?
Yes, it might be reflected. Justice Nair was there.
But in the office note, it is written you have not filed.
No,
Affidavit.
lordship.
Coordinate bench and then meantime, okay, in the meantime, may file their affidavit. What is affidavit in criminal
Exactly,
petition?
lost.
But then there is an order
Yes.
and there is no order that you have said that you will not be filing.
On, yes, lordship, basically, I didn't mention that.
Maybe
that-
it's in the other one, let's see. But then these are other of this.
Affidavit. Required name, okay.
Oh, yes, it's in the other file.
Yes,
Yeah, it's in the, this Nair's.
yes.
He would not be filing the counter in the matter
Yeah,
and would be relying on the basis of the details available on the.
yes, that's.
So what is the matter about?
Lordship, the petitioner in item number 8 and 9 are husband and wife. Case has been filed against them by a third person. Now, Lordship, the FIR is at page 15.
Matter is admitted.
Not
Yet, not
yet. I was hoping your Lordship would dispose it off on admission.
All are
Little-
represented. You are there for respondent
For
number two.
respondent number 2. Complainant.
Okay. Yeah.
Lordship, before reading the FIR is just so that we save some time. Is
Is
to
this for what order? What problem? This is for what?
quashing of FIR.
Only the FIR.
Yes, FIR.
Cognizant charge framing, nothing is done.
Till now, nothing is done. Lordship, FIR starts at page 15.
Yes.
Annexure 1. The date of the FIR is 29/9/2024, 29th of September 2024. The is that of 31st August 2024. So there's been a delay of almost a month, 31st August. Then Lordship may see the contents of the FIR. Since in the format it's very small and the typewritten one, the actual complaint is also it's not very legible. So I have taken the liberty of typing it. Page 25 is a type copy. FIR against Irfan Tazam and his second wife, Mike Kotin Tazam and others for criminal conspiracy, wrongful confinement, assaults, snatching, blackmailing and extortion of huge money by blackmailing and threatening to lodge false defaming level. Sir, I'm presently serving as EERWD in Changlang district and during the last
Is some stay operating?
No.
Okay. I'm presently serving.
I am presently serving as EERWD in Changlang district and during the last part of August 2024, I had gone on casual leave to attend an important domestic work at Alo. On 28th August, Srimati Mai Kotin Tajam, that is the petitioner in item, the wife of, who is casually known to me as her first husband and brother were known to me, and she being a friend on Facebook asked me on Messenger if I was at Alo, as she might have seen my FB posts, etc. When I replied that I was at Alo, she asked me to visit her at her rented room on 29/8/2024 at 10:30 a.m. But I could not visit her as I was busy. Then again on 31st August 2024, she reminded me and told me to visit and meet her at 12 o'clock midnight. She even asked me my mobile number, which I had shared in good faith. She called me at 10:30 p.m. from a bar when I said I could not come at 12 midnight, and she asked me to come at 11:30 p.m. Therefore, I visited her rented room at Bogdo on 31st August 2024 at 11:30 p.m. And as I had never visited it earlier, she came up to the balcony and signaled me with her mobile torch flashlight and guided me to her room. As soon as I went inside, she told me to remove my clothes and also take shower as it was very hot.
This is for what purpose today? Coming up for the first time.
Yes, this is should have been listed in motion. My lord, I'm assailing order dated 27/11/2024, 5. 24, passed by the senior division ALO. Have not done my delay application of 353 days.
350 days.
So
Let me issue notice to the respondent.
in the meantime, my lord, the cover decision may be stayed. I mean, the Jini family decision.
No, now it is only for condonation
Condonation
of
of
delay.
delay.
So
But-
how can I stay the Keba decision without the appeal being brought on record?
But because my lord, actually, I'm the mother, and respondent number 1 and 2 are my daughter-in-law and son. And that the said dispute property, I was collecting rent since more than 3 decades. I'm 80 years old now, and because of this decision,
Merits, I will hear it when I'll hear the second appeal, because this is second appeal, right?
yes, second appeal.
So now that the delay is not condoned,
Yes,
so let me issue notice first to the respondent.
yes, my
Okay,
lord.
there are 2 private respondents.
Yes,
So only after condonation of delay, I'll go to the second appeal.
my lord.
This is, this is, oh, this is
My lord, may
only
kindly
against the
my lord,
refusal of.
my lord, may kindly see, I'm around 80 years old, and I have no other source. Only that building I'm collecting rent. That to very minimum.
No,
And
what-
because of the decision now,
No, it is only against refusal of condoning the delay,
yes,
right? So here only notice will go next day.
she is there. She is my granddaughter.
Oh, acha. You are for the private respondents, but notice
Yes.
have not gone.
Notice has not gone. I had in fact filed a caveat which has expired. I was just listening if the notice is to be gone, Your Lordship. Because since this is the second appeal, until the matter, the substantial question of laws are not made, the court cannot admit this. There is no question of
She may now respond and
So no, only
receive the
notice today.
notice.
Heard Mr. So and so. You are?
My lord, may I pray, let her receive the, not formal notice may be required. Let her receive the,
No, they are private respondent. You have to serve notice upon her. Okay. Then we heard Mr. So and so for the appellant. This is item number 10. Your Marto Kato.
no M at.
Okay, MAP for the appellant. This petition, this second appeal is filed under section 100 of the CPC 1908 for setting aside and quashing of the impugn order dated 27/11/2024, passed in miscellaneous case number 58 of 2024, in civil appeal number 18 of 2024, passed by the learned civil judge, senior division, West Siang district, Alo, Arunachal Pradesh, by which the learned court had declined to condone the delay of 353 days. Issue notice to respondent number 1 and 2.
My lord, pics that may be given.
The
24.
petition- Let the notice by registered post then only.
Yeah.
The petitioner would take steps for service of notice upon respondent number 1 and 2 by registered post with AD. Returnable by 3 weeks.
List after posa.
Leave list after 2 weeks. On a date to be fixed by the host.
Yeah, please, my lord. My lord, today I'm praying for the consideration of the IA, which is for the suspension of sentence and consideration of bail. My lord, in this case, the conviction is only for a fixed period of 5 years.
Wait. You are moving IA today.
My lord,
Where is the IA?
my lord may kindly
Wait.
Since the paper book is prepared in this case,
Criminal appeal.
my lord, criminal appeal 10 may be kindly be taken up first, my lord.
10.
10, my lord.
I is 44.
Yes, my lord.
No, I is 40. 43. You want me to take up criminal appeal 10 first?
My lord.
Then I is 43. This is
50
sentence for what?
5 years, my lord, under for selling and possessing of intermediate quantity, my lord.
Intermediate quantity.
8 kilograms of ganja, as per the allegation, my lord, and as per the conviction.
And what about the other case? There are two accused persons.
So accused, my lord. She has been convicted for possessing of 3 kgs of ganja, and same conviction 5 years, my lord. 3 years, my lord.
Fire.
Same FIR. Altogether, there were
together.
4 accused, my lord. 2 other accused were convicted for commercial quantity. Those are different, my lord. They are not before, my lord.
Okay.
And moreover, my lord, the paper book has been prepared. If my lord may kindly have the paper book, I'll just refer to that.
The paper is also prepared. Why didn't you go for final hearing?
Yes, Your Lordship. If already paper book is there.
25. It will take some time.
My lord.
Okay. Let's
My
go
lord.
with the IA.
But at the outset,
Show
my
me
lord,
where is the FIR?
FIR, my
I will
lord,
not go deep into the matter.
my lord,
But
page
just
number,
show me what is in your favor.
my lord, 1 to 4, my lord, FIR.
1 to 4.
My lord. The relevant would be page number 1, my lord.
The contents of the FIR is where?
My lord.
7.
My lord, I am to inform you that basing upon the
No,
information,
I'm not getting where.
paper book page number 1, my lord. First page. FIR. I am to inform you that basing upon the information received from reliable sources, search and raid were conducted on 31/3/2018 morning at different locations of Itanagar and Naharlagan area, wherein huge quantity of ganja have been seized, approx 130 kgs. Beside that,
On some secret information?
yes,
Upon
on the
it.
basis of department. One male, namely so-and-so of Tarajuli, Naharlagan, and 3 women, namely Simiti Yareyova of J Extension, Naharlagan, Simiti Charumala of 6 kilo, Itanagar, and Simiti Muriyai, my lord, is the present appellant of 6 Itanagar, Muriyai. Have been
Gui.
yes, ma'am.
Where is Gui? Yes. Of 6 kilo.
Have been detailed
What
bad
detailed
for
bed?
indulge in selling of ganja in capital complex area.
Have been detailed bed. What is that? Show me the original.
Original, my lord, it's in page number 3. Have been detained who are indulged in selling of ganja.
Have been detailed.
Detained.
Detailed
There
bed.
was a missing of,
Look at the translation by the registry. It is done by the registry.
my lord.
Okay.
My lord, at the outset,
See, hey, 1 second. Six kilo is some area.
6 kilo, name of the area, my lord, between Itanagar and Naharlagan, my lord.
Then
In this case, my lord, the appellant presently, my lord, is a lady with 4 minor children, my lord. And before conviction, my lord, she was serving as a Gram Panchayat member. In fact, she was a responsible person, in fact. Now, my lord, altogether, I have 3 grounds for the interference from my lord. First ground is that, my lord, there's a clear violation of section 1, section 4 and 5 of the CRPC. There's no independent witness to the search and seizure, my lord.
there may not be independent witness.
But there were official, one official witness, my lord, she has denied. And thirdly, my lord, the seizure witnesses, my lord, have acted merely as an attester, my lord, nothing else. Have only attested, but otherwise they have not seen the seizure.
First one, you said no independent witness to the search and seizure. Then?
Now, secondly, my lord, the prosecution has failed to justify that the alleged contraband, which has been seized from me, ganja, falling within the definition under
Why
NDPS.
FSL report is not?
Yes, my lord, but that is different. it does not come, it is not in consonance with the definition of NDPS, my lord. Ganja.
Then,
The number 3, my lord, the integrity of the alleged contraband has been compromised in this case. The integrity of the alleged contraband, my lord, has been compromised. In the way, my lord, if my lord, I'll just show from the records, my lord. Firstly, if I may take my lord to the definition of NDPS, my lord. Definition of ganja in
before that, just show me the evidences under which he has been convicted.
Okay.
What are the evidences?
The judgment starts from page number 58. Right?
No, entire judgments you don't have to put the
Relevant.
convictions. On what grounds he has been convicted? Was recovered from the possession of the again. There is no procedural lapse. No procedural lapse should be lapse.
Only on the ground that I was the 8 kilo of contraband was found in my shop. Solely on that basis.
Shop.
Yes. At 6 kilo.
So there are no procedural lapse.
In fact, we are alleging there's a non-compliance of 42, my lord. But since there are certain authorities where the officer himself is a gazetted officer, then my lord, the compliance of 42 may not be required.
Will not be.
That is a reason we are not pressing on that, my lord. Otherwise, my lord, there's a clear violation of section in respect of the search and seizure, my lord.
What violation?
Violation of since there's no independent witness in the search and seizure, my lord.
There may not be. There are judgments even police officials will do.
Yes, my lord, even I can justify, my lord, when 2 other judgments, my lord, where Honorable Court has interfered. Otherwise, my lord, the vital part is that the my lord, prosecution has in fact miserably failed to justify that the contraband itself is a ganja. I can show it from the record of the FSL also.
Okay, show me that.
If my lord may kindly have page number, first I'll just read the definition of the ganja. Section 2 definitions, man. Section 2, subsection 3.
Cannabis.
Cannabis hemp means charas, my lord, is not relevant. Ganja, that is the flowering of fruiting tops of the cannabis, my lord. Excluding the seeds and leaf when not accompanied by the tops. It defines that the flowering of fruiting tops of the cannabis plants. If it's seeds or leaves, it will not be covered under this definition. Now, if my lord may kindly have the forensic examination report, my lord. Page number 18 of the paper.
Page number?
18. The relevant part is page number 19, man. This is a report down below, man.
Greenish colored dried plant.
Plant, substance with seeds and leaf is stated to be ganja, man. This is not in consonance with the definition enumerated under the NDPS Act, man. It has to be the flowering tops, man. Fruiting of the flowering tops.
Colored dried plant substance.
Yes.
Okay, even if we leave aside the seeds and leaves,
Right.
a dark greenish colored dried plant is there.
Plant, only plant, madam. Plant will not fall within the definition of ganja, madam. It has to be the flowering of the fruiting tops, madam. Even I can, to substantiate my submission, madam, I can take my through to certain judgments, madam, His Honorable Court. Now, if my lord may kindly have page number 39.
Of the paper book.
Yes, madam. This is a deposition of the expert.
39.
My lord.
Okay.
On oath.
I have subjected the samples received at CFSL.
Serial number 3, madam.
Samples tested positive
For
for
cannabis, madam.
Given my opinion, 80,000. These are actually
Yes, ma'am.
Central.
Central. So
This is after the FSL.
yes, ma'am. This is a deposition, my lord, before the court. Ma'am.
But what is FSL? No expert from the FSL is examined.
He is the expert, my lord.
He is actually CFSL, Central Forensic.
Forensic science.
It is only when the copy is given to the accused person and he wants to send it again, then it was sent to a CFSL.
CFSL. ma'am.
So cannabis includes ganja.
Cannabis is just a plant, my lord. But in order to bring within the definition of ganja, it has to be the.
So cannabis includes charas and ganja.
Yes,
in
ma'am.
any mixture. So ganja you are saying that it is only the flowering top,
Fruiting and flowering tops, my lord.
but not the leaves and all.
Not the leaves, seeds, and the plant, my lord.
But CFSL person has said that it tested positive for cannabis.
Cannabis,
Cannabis can include ganja.
My lord, if altogether, if combine this whole, contraband, my lord, it has come to 8 kilo. Say, for example, if it has been segregated, say, for example, tops, and it has been segregated, my lord, it could have come within the definition of a small quantity also. So therefore, my lord,
These grounds we have not raised before the trial court.
not that issue has not been raised, my lord. But since I'm in fact on the issue of law, that this definition does not fall within the meaning of NDPS Act as ganja, my lord. Since that is only the it has to be the flowering or the fruiting tops, my lord, not the seeds and leaves, my lord.
But that can be a ground for bail, suspension. Because suspension, you have so many judgments showing that, of course, there can be so many grounds for suspension. Right? There are judgments, I believe, right, by the Supreme Court.
Yes,
What
and
exactly?
serious case, suspension usually don't take
Because
place.
these points, again, you can raise.
During the hearing also, my lord. But my lord, I'm only trying to show that there's every possibility of succeeding this appeal, my lord. That is the reason. And since this, the offense is fixed for a period of 5 years, my lord. In carenas of authorities, my lord, when the offense are fixed for 5 years, usually, my lord, the learned honorable court has considered.
Had it be a case like it's not at all a contraband, then it would be different. But here it is said ganja in the
It has only said
with leaves and so, it can come down.
I'll just place 1 or 2 authorities on this ground, sir, my lord.
Only on this ground?
On this ground. Otherwise, my lord, I have other ground is that the integrity of the alleged contraband has been compromised, my lord. If my lord may peruse the date of the seizure and the date of forwarding, the messengers who ought to have been examined, the lab who has taken the sample to the laboratories were never examined before the court. There's no Malkhana record as such, which has been placed before the court.
Absolutely.
Yeah, my lord. These are the grounds, my lord. But mainly I'm focusing on the since I can substantiate by way of some authorities.
Okay, show me, sir. Show me the judgments.
Since I could not get hold of any Supreme Court judgment, my lord, I have 2 High Court judgments in this.
One thing. Just wanted to take out the judgments on suspension of sentence.
My lord, suspension of sentence, I have 1 already.
Okay.
It's a very short judgment, my lord, not in respect of the definition, in respect of 389, my lord. I'll just read the first 2 paragraphs.
Which paragraph? Only 3 paragraphs. Second paragraph will do, Nike?
Yes. When the convicted person is sentenced for fixed period of sentence, when he files appeal under any statutory right, suspension of sentence can be considered by the appellate court liberally unless there are exceptional circumstances. Of course, if there is any statutory restriction against suspension of sentence, it is similarly when the sentence is life imprisonment and consideration for suspension of sentence could be of a different approach. But if for any reason the sentence is of limited duration, cannot be suspended, every endeavor should be made to dispose of the appeal on merits, more so when motion for expeditious hearing the appeal is made in such cases. Otherwise, the very valuable right of appeal would be an exercise in futility by efflux of time. When the appellate court finds that due to practical reasons such appeals cannot be disposed of expeditiously, the appellate court must bestow a special concern in the matter of suspending the sentence, so as to make the appeal right meaningful and effective. Of course, appellate court can impose similar condition when bail is granted. In this case, the High Court was not inclined to hear the appeal expeditiously. We are of the view that a sentence passed on appellant can be suspended on the same stringent condition. We therefore suspend the sentence and direct the appellant to be released on bail, on each of them executing a bond to the satisfaction of Additional Session Judge Nadir. We direct the appellant to report the so and so, my lord. In this case, my lord, the sentence was for a period of 10 years, my lord.
5 years.
In this
case.
case. Otherwise, my lord, in respect of definition of ganja, my lord, I have placed the authority.
This one?
Yes, my lord. Page number.
Africa.
Yes, my lord. Page number 3, my lord. Kindly, paragraph 10.
Paragraph?
10, my lord. In the first instance, we have to go on the premise that prosecution charge against the accused is based on alleged seizure of ganja. Ganja is defined under the provision of NDPS Act as follows. 2, subsection 3, clause B.
Okay, you can leave that.
That
From this
is
definition.
the flowering or fruiting tops of cannabis plant, excluding the seeds, so and so on. From this definition, it is clear that ganja would mean only the flowering or fruiting tops, excluding the leaves as also seeds. In the instant case, the prosecution has produced seizure Panchnama, Exhibit 5, to show what was seized. It read as follows, madam. From the extracted portion, it is seen that officers have seized are cannabis plants, madam. The description of the seized product shows it had stems, leaves, branches, and perhaps even the fruiting parts. But the question is, can the stem, leaves, branches be termed as ganja in view of the definition referred to above? The answer is obviously in the negative, because the act itself defines what is ganja. Not only the raiding party, but the investigation officer has not separated fruiting tops or flowering from the ganja plants before weighing well. What has been done is they have weighed the entire plants to record the weight as 10 kg. Since the leaves, stem, and branches were also part of the weight mass, there was no weight of actual flowering or fruiting part of the plant defined as ganja. Hence, the evidence produced before the prosecution to sustain the charge is totally vague. If the whole plant is seized, then it will only be cannabis plant and not ganja. Initially, the charge against the accused was for the offense punishable under Section 20A(b) of NDPS Act, but the trial court found them guilty only for the offense punishable under Section 20B(I) of the Act. There is no conviction for the offense under Section 20A of the Act. Hence, it was incumbent upon the prosecution to establish it was ganja as defined and its weight. This makes a difference because the punishment prescribed under so and so depends on the quantity of the contraventions. The Act describes three quantities: small quantity, lesser, commercial, but the greater than the small quantity and commercial quantity. Basically, my lord, all I'm trying to prove from this case is that, my lord, it has to be the flowering or the fruiting tops, my lord. Mere having the plant or the seeds and leaf will not be considered as a ganja. And similarly, in the present case also, my lord, there's no flowering or fruiting tops of the cannabis plant.
Yes, with seeds and leaves, but then dark greenish colored dried plant substance.
Plant,
Whether those are flowering and fruiting tops?
no, only the plant. It says that eventually it's plant, my lord.
Okay, by segregating the seeds and leaves, as you have said, the quantity will become less. But the fact remains it will be ganja.
That has to be, my lord, since it has not been justified that it is ganja, only a mere statement. Otherwise, there's no any definite explanation as to what are the contrabands which they have been seized during the investigation. Para 7 and 8, my lord.
If you read the definition, ganja, which excludes.
The main contention of the learned counsel for the petitioner is that the seized ganja of 750 grams is containing the leaves and seeds, which is not considered as ganja as per the provision of Section 2(3)(b) of the NDPS Act. In order to verify the same, it is worth to mention the provision of Section 2 so and so. These are the definition, man. If you read the definition, ganja, which excludes the seeds and leaves, contains flowering or fruiting tops of cannabis plant. In the complaint, especially Caesar Panchnama, which reveals that the bag in possession of the petitioner looked like a leaf. but it contains the flower, fruit, and seeds. Considering the same, it not only contains the seeds and leaf, but also accompanying flowering and fruiting tops. Therefore, the material seeds is containing flowering and fruiting tops accompanying the seeds and leaf, which amounts to ganja. That is, the leaf and seed accompanied with the flowering or fruiting tops of the cannabis plant. It falls under ganja. The conclusion is only the leaves and seeds not accompanied. Then it cannot be considered as ganja. In order to exclude the definition of ganja, the seeds and leaves shall not accompany the tops and fruits, my lord. In this case, my lord, it is the seeds and leaves, my lord, along with the greenish plant. So there's no definite, a specific definition, a specific finding, whether it is the flowering or the fruiting tops, my lord. Otherwise, my lord, since this is only for the consideration of IA, my lord. Since
There is no finding on that, right? That
No.
the question was not
no
raised.
finding.
Okay, what do you say? Mr. Loy? What do you say?
Yes, Your Lordship, this is an NDPS case. This is an NDPS case whereby ganja was seized. Forensic report says, it clearly says, indicates that it is positive. The seized material is ganja. And nowhere it is, yes, only ganja was seized, not like something flowering things and leaves. That is not mentioned.
The CD report, it says so-and-so sample,
Yes, in page 20.
dark greenish colored, dried plant substance with seeds and leaves, even if you leave seeds and leaves, stated to be ganja.
Yes.
Stated to be ganja. They even did not give a final opinion on that.
Since she is a lady with 4 minor daughters, my lord, and as well as, my lord, she is a responsible person, in fact. So at this stage, since the conviction is only for a fixed period of 5 years, considering that aspect, my lord, my IA may be considered. Rest, my lord, subject to the outcome of the main appeal, my lord. Only in that ground itself.
What do you say?
Since paperwork is already ready, so it may be fixed for final hearing.
But on this ganja part,
Yes, it can be put up together and, on that day, maybe if she finally, appellant finally become an innocent, she will be acquitted only.
but she is a lady, and with that ganja is also not properly stated
Yes,
that
it
it
is-
is a
it is-
ganja, it doesn't come within. So let her go on bail and the matter will be heard. Because 25 matter, it's not an old matter also, it will take years and 5 years conviction.
Yes, your
Ready, but
also wisdom prevails.
since paper book is ready, can you do the hearing in a short date?
It may take some time now. After break, my lord, the possibility of taking time. Only on that ground, my lord, may kindly consider, and subject to the outcome of the appeal, since I'll have to face the appeal, and in case if the matter goes otherwise, my lord, she'll have to go back again.
Where is your I application? Where have you mentioned that she has for small children's?
I 43, my lord. In paragraph,
44
I've met the annexures, my lord.
And the other one is also a lady.
My lord, and it was only 3 kgs of ganja in her, from her possession, my lord.
Okay. As far as this one,
So, my lord, para 4 of the IA, my lord. It starts from annexure 4 series. Page number 42, my lord, starting from.
I've seen. What 42?
Page 42 of the IA.
She is Rudy Yai.
Yes, madam. And 43 is the other
43.
43 is the other daughter, madam.
Let me deal with 43 first. 43 is connected with 10, right?
Yes, madam.
And 44 with 11.
My lord.
Right.
IA page number 42 is the birth certificate.
Right, Mr.
J. Sering.
J.
Sering.
J. Sering, yes. T. Sering.
J.
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 J. Sering. Heard Mr. J. Sering for the applicant. In the IE, you write, huh? And Mr. G. Tado, additional public prosecutor. G. Tado, right? G. Tado, no, this is an application. Filed under section 430, subsection 1 of the BNSS. Praying for suspension of sentence and the subsequent bail during dependency of the criminal appeal registered as Criminal Appeal 10 within bracket AP of 2025. The applicant has been sentenced, has been convicted under section 20 in bracket B within bracket small Roman 2 within bracket B of NDPS Act and was sentenced to RI for 5 years with fine and default stipulation. By the court of Learned Special Judge NDPS UPR. NDPS case number 4 of 2018. I've not given the judgment, no? White impugned judgment dated, judgment and order dated 28/4/2025. The prosecution case, as is revealed from the FIR lodged by the inspector, what lodged by the SDPO.
Yes.
Lodged by the SDPO Itanagar, dated 31/3/2018, is that upon information received from reliable sources, a search and raid was conducted on 31/3/2018 at different locations of Itanagar and Nahalugun area. And during the search, a huge quantity of ganja were seized. Full stop. It was further stated in the FIR that the petitioner, along with 4 others, the applicant, not petitioner, the applicant, along with 4 others, were detained. Were found indulging in selling of in capital complex area and were detained in pursuance thereof. The learned trial court, on conclusion of the trial, had convicted the applicant One thing, Mr. Zering, you did not actually confront, we did not cross-examine the CFSL officer on that point.
My lord, to my understanding, I feel that that is a question of law, since that is due to the definition of NDPS, definition of ganja. So that has to be, since question of law can be raised before my lord for the first time also. That was my understanding.
Question of law can be raised, but then whether it is actually ganja or not, you did
Yes,
not
ma'am.
question that.
Ought to have been cross-examined, ma'am. That was the fault on the part of the defense, my lord.
On what ground the trial court had convicted you? On what main grounds?
On the ground that the 8 kgs of ganja has been recovered from my shop.
On the ground that the prosecution has proved the case beyond reasonable doubt that the applicant along with in furtherance of their common intention had stored the ganja. No. For supplying to the shop for sale to addicted person. On the ground that in pursuance to the common intention of accused number 1 and 2 are whom? The co-accused.
Other co-accused, ma'am.
In pursuant to the common intention and criminal conspiracy with of the other co-accused. The applicant was found selling ganja to the addicted person from her shops, as the same was recovered from the possession from the said shop of the applicant. The learned trial court also held that the applicant, along with Srimati Charumala, used to sell ganja from their shops and that on 31/3/2018, intermediate quantity of ganja weighing 8 kgs were recovered from the shop of the applicant. She yes. She is the shop of the applicant. And as such, the offense under 22B, 2B, NDPS was meted out. The counsel appearing for the petitioner has mainly based his argument on the ground that the contraband recovered from the applicant was not proved to be ganja as per the definition of ganja in the NDPS Act 1985. He has placed the definition of ganja enumerated in section 2(3). 2 is main 2 and 3 is Roman 3. 2(3)(b), small b of the NDPS Act 1985. Which is reproduced below. Start with an inverted comma. Ganja, that is the flowering or fruiting tops of the cannabis plant within a start bracket, open bracket, excluding the seeds and leaves when not accompanied by the tops, close bracket, by whatever name may be known or designated. full stop, close inverted comma. He had placed the FSL report dated 26, 26/4, right? Dated 26/4/2018, annexed with the paper book, no, which was exhibited as exhibit number 11, wherein it was described that the contraband seized was, start bracket, start inverted comma, dark greenish colored dried plant substance with seeds and leaves stated to be ganja, and within bracket cannabis. Full stop. He had also placed the statement. Where is that?
Statement is at my lord.
The deposition. He has also placed the deposition of the scientific officer of the CFL.
Page number 39.
What, 30?
9.
He has also placed a deposition of the what? Junior scientific officer.
Right.
What did I write? What did I say? Of the junior scientific officer of the Central Forensic Science Laboratory, Guwahati, who had deposed as PW number. Is PW number what?
My lord is 7, my lord.
PW number 7, and who stated that he subjected the samples to chemical test and that he found the samples positive for cannabis. The council as such states that it is not proved in the instant case. No, the counsel for the petitioner as such states that the scientific officer of the FSL did not clearly stated as to whether the contraband sent for testing was charas, ganja, or any other mixture. He simply stated cannabis. As such, the council states that there is discrepancy as far as the contraband is, there is doubt as to whether the contraband was ganja in its proper definition or it is some other materials. On the other hand, he also states that the applicant has states that
4 minor children.
applicant has 4 minor children to look after. As he has pleaded in his application at paragraph 4 that all the children were dependent on her, and that her husband is an unemployed person and an old aged person. He has also annexed the necessary documents showing the same in his petition. On the other hand, Mr. G. Tado, Additional Public Prosecutor, states that since the paper book is ready, it will be taken up for final hearing. He also states that the matter relates to the recovery of contraventions under the NDPS Act, which is a destructive, the matter relates to what the NDPS Act, which is a menace to the society, and as such, the applicants should not be released on bail, or the sentences should not be suspended. Heard learned counsel for both the parties, and I have heard learned and I have produced the reports. From the definition of ganja, as shown by the counsel for the applicant, it is clear that only that ganja includes only the flowering of fruiting tops of the cannabis plant, which again should not include the leaves and the seeds. Full stop. In the FSL report, it is stated that the contraband is a dark greenish colored dry plant substance. Dark greenish colored dry plant substance with seeds and leaves. On prima facie, full stop, on prima facie examination, it does not reflect that these are the flowering or fruiting tops of the cannabis plant. The FSL report also shows that seeds and leaves are also present with the contraband seized, which again, in view of the definition, cannot be included in ganja. Further, in the FSL report, it is stated that the contraband is stated to be ganja, and within bracket, and stated to be ganja, within bracket you write cannabis. Stated to be ganja cannabis. Without any clarification, without any further clarification as to whether it was ganja or it can be charas and other mixture. Whereas the junior scientific officer of the CFSL, Central CFSL, states that it is cannabis. Full stop. Although the said aspect should have been raised during the trial, and the scientific officer of the CFSL should have been questioned on that by the defense. There is nothing on to show that there was any cross-examination on the point of on the point as to what contraventions were seized from the applicant. The same cannot be agitated at this stage. However, the counsel appearing for the petitioner had stated that the instant a law point can be raised at any stage of the proceeding. And that since this appeal is a continuation of the criminal proceeding, he has a right to, he has stated before this court. He has taken the said ground before this court. Further, the ground that the applicant had minor children to look after, that too 4 in numbers, the same is considered by this court. As such, this court suspends the impugned judgment and order dated 23/4/2025 and the sentence order dated, no, same day. Suspends the impugned judgment and order as well as the sentence dated 23, oh no, sentence is different. And sentence order dated 28/4/2025 passed by the Learned Special Court NDPS UPR in connection with NDPS case number 4 of 2018.
18.
You have given a dot there. 4 of 2018. And as such, enlarges the applicant on bail during the pendency of the appeal. Till the appeal is disposed of. You can write before that, before the suspension. Further, the appeal is registered in the year 2025 and the applicant is sentenced for 5 years incarceration, or 5 years is sentenced to a 5-year incarceration. Since
he has been in custody since last 86 days.
Huh?
Since he has been in custody since last 86 days.
And it is noticed that the applicant has been inside since the day of the judgment. Before that, she was there during trial.
22 days.
22
2 days.
Not really. Has been inside the jail since the day of judgment. And also due to the fact that the hearing of the instant case would take some time. And since both don't write, and also that the hearing of the instant appeal would take some time. Full stop. You add that before this. Okay. An appeal.
Your Lordship, this is a common judgment and order whereby 4 accused were convicted. So it may be a particular to this instant applicant. Suspension of sentence.
See, this applicant only.
Yes.
Because there are other accused.
Yes.
No, it's only applicant. Nuri,
Oblak.
Yai. Oh, if you can also say he has placed one judgment in his argument. The counsel for the appellant, he has also placed a judgment delivered by the Honorable High Court of Karnataka in Rangappa versus State, reported in 2022, Supreme, within bracket KAR, Karnataka 467. In which it was stated that the seized item looked like a leaf, but it contained the flower, fruiting top, leaves, and seeds. What did this judgment say? In order to exclude the definition of ganja,
The seeds and leaves shall not accompany the tops and fruits.
in order to exclude,
The definition of ganja, the
it should
seeds
be
and leaves.
included or what?
Exclude, my lord. In order to exclude the definition of ganja, the seeds and leaves shall not accompany the tops and fruits. If there is seeds and leaves, it cannot be
Acha,
considered as
which states? What did you say? No, no, don't cut that. Before that, what did I say? He had placed the judgment. So and so. When reported in so and so, wherein it was stated that a contraband to be a contraband which can be stated as ganja should not include the seeds and the leaves. Full stop. That is all. And what about the next one?
My lord, in this case, instead of applicant, can it be appellant, my lord? Since in 3 IA application, my lord, it has been filed on behalf of, on her
let
behalf.
me get rid of this. Age is 10. 10 is 43.
43.
Oh, okay, this is disposed in this matter. The suspension. I stands disposed of.
Yes.
And then this one. She is also another lady, Charumala, from where 3
My
kgs were
My lord.
recovered.
Same case, my lord. Even she has 3 minor daughters, my lord. And only 3 kgs of ganja has been recovered from her.
What 3 kgs from both?
Yes, my lord.
That is what
Including.
trial court stated.
1 8 kg and 1 3 kg.
Is it?
Yes.
The trial court stated 3 kg, 3 kg.
8 kilo and
There is a
3
mistake.
8 in 3.
Same things will follow. Same only Charumala, only the applicant will change. She also has a minor children.
Yes, ma'am.
How many?
I'm altogether 2 years old. Only 2.
2 minor children.
2 minor children.
So in place of 4, you write 2. And in the criminal appeal of both this, since the paper book is prepared, in the criminal appeal, it is seen from the records that the paper book is, it is noticed from the records that the paper book is prepared. So the registry is directed to list the matter for hearing in its usual course.
Right. Grateful, man.
In this appeal also, the same thing will be written. From inquiry report, what is this?
Preliminary, during pendency of lordship, this is quashing application by on the basis of settlement between the parties. The settlement was arrived just within after the 15 days of registration of FIR.
Settlement within 15 days.
Yes, Lordship. Because after registration of FIR, the complainant will came to know that the accused involved in this case is a minor child in conflict with law. Therefore, on that ground and on considering his prospective age, career, they have settled the issues. And thereafter, we have filed this criminal application. During pendency, preliminary inquiry report has already been filed before the Juvenile Justice Board.
But then the matter was settled. What happened to that?
Despite of that, since there is a non-compoundable offense registered, therefore they proceeded with the investigation and preliminary inquiry report has been filed. So accordingly, on 18, matter was listed before this honorable court for consideration, whereby the IO of the case, they sent a informed to this honorable court through WT message saying that preliminary inquiry report has already filed, charge sheet has already been filed before the JJB board. Accordingly, direction of this honorable court, I often leave of this honorable court to file a additional affidavit by bringing charge sheet as part of the records, which petitioners jointly already filed.
Okay. So you have filed the.
Yes, I have already filed additional affidavit by bringing preliminary inquiry report as a part of this pleading. So now both the petitioners, the complainant and the accused, minor accused, they are praying for the quashing of the FIR and the charge sheet, Lordship.
On the ground of settlement again.
On the basis of settlement. Lordship.
Now it's already 4:30.
Yes, Lordship. That's why I have to pray. Tomorrow is the weekend. Tomorrow, Lordship.
Day after tomorrow.
Day after.
Due to paucity of time, the matter could not be heard. List the matter on. Day after tomorrow is what date? 3rd.
Today is Monday, Tuesday, Wednesday.
2nd of July.
Okay. Deeply obliged, Lordship.
The bench assistant will give you the dates. Okay, we'll take it some other day.
Sure. Obliged.
In all other matters, we have to give time. There's no way out.
Your Lordship, short date may be given because CD is already there.
Second, due to paucity of time, could not be taken up. List it on. After the vacation?
No, after you.
No, list it on 2nd of July, day after tomorrow.
Day after tomorrow.
June, or July, yes. Yeah.
My lord, may I make
At your criminal appeal, I could not.
Yes, my lord.
So.
Can we have it tomorrow, my lord?
Tomorrow again, difficult. Day after tomorrow? Give a try. Tomorrow I have a division bench also.
All right.
My lord, I am for the informant victim. Day after tomorrow, I am be available. You know, I have
be
some,
available.
yes, I have some domestic.
This is a POCSO matter.
No, not
No.
also 376.
Rape matter.
Yes.
So then,
Yeah, after vacation.
after vacation.
My lord, then order may be passed to hear the matter as pass item in the let the
Hey,
matter be
it's okay.
discussed.
After the vacation, it will be taken up.
My lord, again it will be not reached. This is the third consecutive date we have appeared and it could not reach.
What can we do? We are human beings. We cannot go so fast also.
My lord, usually this kind of order is passed. List the matter in the top of the list.
Okay, due to paucity of time, this criminal appeal could not be heard as prayed for by the council.
We
The matter
will-
immediately after. Okay, list the matter on 22nd of July.
All right.
No, your lordship, I won't be available.
Huh?
I won't be available. As I won't be available. 22nd. I won't be available. I think I'll give you. 30 or. Huh? 30, your lordship. 30th of July.
Yeah, because 24, I have a case in a district court, your lordship. I'll be leaving on 22. It will take time.
No problem.
On 30th of
I'll
July, as prayed for by the council, list the matter as a hearing matter in the hearing list.
Yes, my lord.
As a first.
No, not hearing list. In the top of the list, my lord.
And this
No,
is fixed for hearing. How can I bring it to
No,
admission
no,
orders?
that can be done, madam. Your lordship can done.
No, as a first item in the hearing list and a he
Again,
and he is further, the council is allowed to make a mention in the morning for taking up the matter. You mention it in the morning, we will do it.
So taking up the matter means,
Taking up the matter, anyway, it will be taken up. Okay, don't worry.
Lordship, it's item number 22. That
well, the mention part may be difficult.
Okay, then you delete that mention part.
Mention part means, on that day I have to make mention, that part. This is the matter.
It will come up on 30th.
Pass item in the hearing list.
30th, you again
Lordship.
make a mention, whoever is there.
item number 22, that PP is there. And respondent number 2, services awaited. And here interim is there, interim may be continue. And at least after this pregnant TCR trial court record may be called.
In item 22, you write that heard Mr. Tania Kipa
Yes, Lordship.
for the petitioner as well as MP. Mr. T. Kipa submits that what happened? The Behari is complete, service is complete.
Services is still awaited. Because
Service states that the service is not complete.
So scan copy of the TCR may be called for. Scan copy of the TCR.
Without seeing the records, I cannot actually.
No, Lordship, actually, we supposed to call TCR. TCR has not been called yet, Lordship. That's why on next scan copy of the TCR may be called for.
it's been pending from last September. Lordship.
Then scan copy of the TCR be called. And the interim order passed earlier should continue till the next date. Okay.
And Lordship, may this Dusty may allow, because last time also
The
that,
Dusty, Lordship, in the criminal matter, Dusty is
Where is
not.
Dusty?
yes, but that they intensely not receiving this.
This case.
This is about 427 mischief only, and there is a enforcement issue, but there is no case. Actually, it's a work has been carried out by the department, and that
Criminal petition.
yes.
So otherwise informant is not required unless it's a POXO vagara.
Yes, Lordship, then informant may be struck out.
It will be done on the next day.
It is come under for merit Lordship. It's not joint
Yeah.
petition. So that's why it is a merit Lordship. It comes under merit.
On merit only.
Yes, Lordship, not a joint petition. So just say Lordship, it notice may be served. If he's participated, then it's okay. Otherwise, Lordship,
Notice
record. Yes, Lordship.
await service report and then your interim is
Yes,
correct.
Lordship.
Okay.
Highly obliged.
List after 3 weeks.
My lord, item number 23.
Which one? Wherever there are interim orders, she'll give a date.
No interim. This is first time, my lord. This is regarding the IA.
Okay, it will be considered on the next day. It will be taken.
My lord, item number
Vacation. But I have to file the reply because I receive of the
It's okay. It will be taken up on the next date.
My lord, I mentioned for item number 16.
Huh?
Item number 16 may be listed on my lord, 2nd of July, my lord.
Okay,
And
16.
item number 33 tomorrow, my lord. This is the new case. 33 tomorrow.
Possible tomorrow. Day
My lord, just CD is
Item
tomorrow
number-
only.
Item number 15, my lord. My lord, item number 15, my lord. Can this be taken up tomorrow or day after, my lord, as per your convenience? Only the of arrest.
Lordship, in item number 21, there is an interim order that may be continued.
Item 21, you continue the interim order.
My lord, I
Matter
beg
may
to
be listed
mention
after
item
three.
number 32, my lord. This is a criminal revision petition, my lord. And it's a case of NI, negotiable instrument. A payment report is, that of payment report is fixed on tomorrow, you know. Yes, Your Honor. On default of the payment, the accused applicant will be imprisoned.
Submitted before the court, pending here, then it will be delayed. It will be postponed. You can take a date there. Okay.
You know, matter may be taken up. It's urgent on tomorrow, my lord. Maybe listed on tomorrow.
There is already a list, so it will be a futile exercise. It will not come up tomorrow. So let it be listed on Thursday then. Okay, on Thursday.
Lordship, I like to mention item number 26. There is an interim order. The interim order may be continued and method may be take up.
Wherever interim office tell her, she will
Yes, Lordship. The matter will fix
What about
after day after tomorrow. Matter will fix after day after tomorrow. The 2nd of July.
After a week, after your interim, you are in interim, what's the urgency? Let it come up after the application.
Lord, Lordship, item number 25, Lordship, there was a stay, interim stay, but because of the non-presence, that this has been, stay has been recalled. Yes, then we have filed the IA, Lordship. Otherwise, we will be arrested, Lordship.
That will be considered. It's okay. That will be considered immediately after vacation. On
Lordship, my Lordship, if it is released tomorrow, then it will take time.
Listing is okay. It will not reach. What will I do?
Lordship,
It's okay. After the vacation.
May it please your lordship, my lord, my lord, we have received the charge, case diary in item number 14 and 16. And your lordship, the default period is 60 days. So now if the CD is not returned or matter is not taken up early, then your lordship, the investigation agency will find difficulty to file the charge sheet, your lordship. Because your lordship is aware on ground of arrest they came and the record was called for and the record, my lord, and ground of arrest, everything has been communicated. So now your lordship, it's almost 51 something days, my lord. So now if it is retained or matter is not fixed, then it will be difficult for the investigation agency to file the charge sheet. So
You send it back and get a scanned copy of the case diary.
okay, your lordship.
Lordship, item number 25 may be on 3, Lordship, because this petitioner is DIGP, then his duty and performance should be, Lordship, hampered by this order, Lordship, impugn order, Lordship.
Okay, listed on 24. You want?
Lordship, if I listen, tomorrow, either day after tomorrow, Lordship.
Tomorrow?
Then 3, Lordship.
Day after tomorrow.
Day after tomorrow. Only day after tomorrow.
Okay.
Oblige, Lordship.